start to transition over to the sentencing guideline review, let me just give you a little bit of an overview of what we hope to cover, and then maybe we'll take a break, and then we'll dive into some of the details of this. So there's four things that we thought we'd try to cover this afternoon. One is just a quick recap of some of the stuff we talked about in July, sort of guiding principles and so forth for this review of the guidelines. And then we promised to do a lot of work on OGS assignments, and we've done a lot of work, but you'll be the judge of if we've done enough and how much more has to be done. Then we want to return to the discussion of prior record score. That's a really big change that we're recommending or suggesting, and we want to continue to sort of chip away at that, go into more details on that. And then we want to just identify what we know are other steps other things we have to work on between now and at least the end of the year to prepare you for sort of a document that you can decide to move forward with or not. So let's just start with a recap, a couple of basic concepts as we were thinking about rebuilding guidelines. And again, this started in 2014, so it's been a long process. But one of the things that we always say is true of sentencing guidelines, whether in Pennsylvania or anywhere else in the country, I guess, is that guidelines are supposed to be a common starting point. We're supposed to use some objective factors to sort of identify the typical sentence for the typical offender. And so we want to come up with some kind of scaling of both current conviction offenses and criminal history, and use that as a basis for having these recommendations. One of the things we talked about during the July meeting especially was about how we define typical sentence or typical offender. And in the past, and you'll see this in the data, sometimes there's a lot of conformity with the guidelines. Judges are sort of sticking with the guidelines. Now, sometimes that happens because there's nowhere else they have to go, right? The guidelines are wide. It's a short statutory max. There's just, you do anything and you're in the guidelines. So that's great. But there are plenty of times where judges have opportunities, and whether it's because of negotiated pleas or because it just seems appropriate, that there's high conformity with the guidelines, a lot of sentences in the standard range. And then there are other offenses that are all over the map. We've talked about murder 3, and we'll continue to talk about murder 3 because it covers so many different situations, circumstances, and you have such a wide range of sentencing options available that just nothing seems to fit. So we're going to continue to look at that to see if we can improve on what we would recommend for murder 3. But then there are other cases where the commission and perhaps the General Assembly is trying to encourage some kind of behavior. They're setting guidelines or setting statutes that take into account a really terrible situation or really great harm and setting pretty substantial recommendations. And in almost every case, judges are sentencing below that. And it could be because, again, it could be negotiated pleas. It could be that for an extreme case, that does make sense, but most of the cases we see, the typical cases are not extreme cases like that. So we see a real disconnect between what we're recommending, which makes a lot of sense when you talk about it, and what we see as far as the sentence is being imposed. So that's sort of the nature of the work we do. And so when we're trying to figure out the typical sentence for the typical offender, one of the things we talked about in July was thinking about the median sentence as that typical value. And remember, the median was the midpoint, right? If you had 100 cases, or let's say 101, the median's like the 50th, 51st value, right? So you line them up from, there's a bunch of probations down here, and there's state prison at the other end, and the midpoint value is the median. And what generally happens is the median's not standing alone. You have 100 or 200 or 1,000 cases, And there's a lot of them grouped in the middle around that 50th percentile, right? So median is that typical point. And that's what we were discussing during the July meeting, that up until this point, a lot of what the commission did in terms of sentencing guidelines was based on just ranking the seriousness of the offenses and looking at things relative to one another. So we really focused on what we call retributive values like uniformity and proportionality. And so we just did the ranking of offenses on a 13-point scale. And where does that fit in? And that makes a lot of sense. I mean, the General Assembly does that in determining the grading of an offense. So it's consistent in that way. But that's different than saying, let's look at 1,000 sentences that judges imposed for this offense, this circumstance, and figure out what they're doing, what's happening in courtrooms. Well, that's the median sentence that we're talking about, and that's based on what's happening in the field. So two different approaches. And what we found was when both of those align, when the recommendations the commission's making and the median sentences by judges are sort of in the same space, then, we've hit the jackpot. That's pretty good, right? And one way to sort of get at that is to think about that midpoint value and then think about whether that's part of the standard range of the guidelines. Is it already in the standard range? Another way to think about it is, in cases where you have really high conformity, like a lot of sentences are in the standard range, then chances are pretty good the midpoint's going to be there too, right? So you're going to see that we've done some analysis to try to figure out what are the cases where these things line up, that what we're recommending and what judges are doing sort of align with each other. Because those, I think you can have a lot of confidence in saying, whatever we're coming up with the assignment of the new offense gravity score sort of makes sense. It's consistent with practice and it's consistent with what we said in the past we wanted. But then we have to spend time looking at when it doesn't connect, when there's big splits, and it splits in both directions, or when there's so few values. There's two cases, there's one case, there's no cases. Like, where do you plug that one in then? Because you don't have any data. So we want to talk about some of those things, and you'll see some examples as we go through this. So again, median sentence, though, is the thing we really focused on this time around, and that's what we're going to talk about in the slides this afternoon. But we always, when we're thinking about what the typical sentence is, the first thing we think about is, what's the disposition? Is this a county probation sentence? Is this a county jail sentence? Is this a state prison sentence? So what's the disposition that's most common? And then for that disposition, what's the duration? Is it 36 months of probation, or is it a 5 to 10? Right. So those are the metrics we're going to use when we're trying to figure out what that median sentence is and how we plug it into new guidelines. So here's some of the other guiding principles for developing these guidelines. The first is we wanted to simplify the guidelines and we wanted to be able to automate them so that there's less work on the end user point. You can rely on the information we're using, and it's just a simpler and more, and practitioners would have more confidence in it. When we had the strategic planning work group, I think Judge Marsko, I think you were involved in that when you were at DA. One of the things we heard from both the defense and prosecution and from the judges was, let's just figure out what this is, and let's have confidence that we'll get that sentence, And if you have a sentence range that includes probation and state prison, then confidence in what sentence you're going to get is missing, right? So the idea was, let's simplify this. Let's sort of boil things down to objective factors, and then let's link that to a disposition and a duration, so that there's a single disposition. This is about a county jail sentence, and you can have confidence in negotiating to that, and you know what's going to come out of that plan, or at least you have a clear understanding of that. So simplification, automation, confidence in what's happening. For the offense gravity score, we talked about targeting, and this came out of JRI 2. So JRI 2 said, you should have a primary disposition. You shouldn't say this is probation and jail and prison. You should pick one because you're making a recommendation to a judge about what you think is typical in this case. And it can't be all three. So pick something. These are advisory guidelines. Judges can go outside of the guidelines. Parties can negotiate on things. So the commission could benefit from being much more directive in a recommendation, especially if you're linking it to the practice in the field. And then narrow those ranges so that you're not giving everything, because then you're really not recommending anything. Aside from deciding what the offense gravity score is, we also talk to a lot of people about trying to have a listing of objective factors that are used to adjust the offense gravity score. So you can think right now that we have some built-in adjustments where we say, oh, if it's an inchoate offense, it's one step lower than a completed offense. But there's a lot of other factors that we see time and time again as reasons for aggravating or mitigating sentences. And so to the degree that you can identify those and give a value to it, you have more consistent sentencing where the same value has the same weight in every case, at least in terms of coming up with a sentence recommendation. Then the court looks at that and decides if that's an appropriate sentence. But that's a separate issue. That's discretion by the court, not what the guidelines are. And then the final thing, in at least what we hope to, or what we talked about in July, was the prior record score. We said that, if you just think about the impact of prior record score, we found cases where the prior record score increased the sentence recommendation up to 10 times what the base recommendation is. And so if that makes sense, the question is, why does that make sense? And why in our guidelines do we say the most important factor is the current conviction offense? So if the current conviction offense is the most important factor, then we should figure out what the right sentence for that offense is for a 0 prior record score, and then figure out how much more you get if you're a repeat offender. And what at least the academic review panel said was, well, the current conviction offense is the most serious thing, is the most important factor, then anything else is secondary. It shouldn't do more than double what you're recommending. So, we're going to talk about exceptional cases, revoc and, 3 strikes, things like that, that might fall outside of that treatment. But for the most part, we wanted to build a scale where the prior record score would do no more than double the sentence recommendation at the base recommendation. And then, so one of those was just focusing on where punishment or sentencing should apply, which is the current conviction offense. The second thing that we were real sensitive to was racial issues, racial disproportionality, other things like that. And when we did the analysis of especially the prior record score, as the prior record score increased, the racial disproportionality increased substantially. And so one way to try to address racial concerns like that, that's within our control, is to think about how we build the prior record score and how we apply the prior record score. So that's why we're coming back with a lot of recommendations about that prior record score. We really think that's an area that we need to look at and think about, and it could also simplify the process. So those are sort of the recaps from the July meeting. So here's kind of the work that we've done since. One of the things we talked about was when the commission is just developing guidelines based on policy, which we've traditionally done, we try to take into account how serious an offense is. And as we discussed in July, usually the sort of the ranking of seriousness of offense usually starts with offenses against persons where there's an injury or a harm to a person is the most serious kind of offending. And the next in line is generally property. And then the third in line is generally public order. So if you think about our statutes in Pennsylvania, look at Title 18, chapters 25 to 32 and 43, well, 25 through 32 deal with offenses against persons. And you see things like, robberies and homicides and assaults, things like that. So there's a direct victim who's a person. Chapter 43 is against families, right? So the persons, we want to think particularly about those kind of offenses when we're thinking about offenses against persons, because that's primarily what we're going to see in that category. The next category down is property, chapters 33 through 41. And I think, sometimes it's a little bit of a misnomer because, if you think about burglary, 3502, there's home invasion burglary. So it's a property offense, but there's a person who's a victim. Burglary of a house, person present, right? So it's not that property offenses do not include consideration of direct victims, persons who are victims, but more often than not, we're talking about the property that's the thing. So burglary, robbery, things like that, you're going to be thinking about persons as well. But property is generally what we're thinking about in terms of thefts or other kind of criminal mischief, those kind of things. And then the third category are the public order ones. So chapters 45 through 77, but also in that you'd include things like drug offenses under Title 35 or DUI under Title 75. So those are the public order provisions, and they're usually third in line. It's not to say that they're not important. It's not to say that there's not felony one offenses in those categories. It's just that if you're ranking the most serious kind of offenses, generally speaking, we talk persons, then property, then public order. So that would be that prescriptive approach where policy is being used to drive how we assign offense gravity scores. And then, as I said, the other approach is to sort of focus on that descriptive approach where we use the data. What have judges been doing? And when there's a lot of data, you can find some pretty good support for sentence recommendations based on the data. When you got two cases, it's a little tough, right? So one of the things that was suggested during the July meeting was, instead of just looking at 2019 data, add in several years of data. So I believe the data set we have is 2017 through 19, yes. Right? So 3 years of data. So if you think about us having, 125,000 offenses reported to us each year, and you triple that, you get bigger numbers in terms of coming up with these median sentences. And some sort of, just leveling, because if there was something that happened one year but it didn't happen the other year, you have a little bit of it leveling. So 3 years of data was used instead of 1 year of data. The final thing is, I mentioned about sometimes what you're prescribing, what you come up with as an assignment because of policy ideas, and what you see in the data, like, coincide. And when we looked at all of the offenses, when we analyzed all the offenses, we found that 80% of the offenses that we analyzed, the conformity rate, the number of sentences within the standard range, were at 50% or greater. So if you think about that, half of the cases sentenced are in our current standard range. And that happened in 80% of the cases. Sometimes it's 100% or 95%. So you start with those 80% and you say, in many of those cases, in most of those cases, the median sentence we're going to recommend is going to be in the existing sentencing guidelines. But our guidelines are pretty wide. So if we have a 6 to 16 cell, that median sentence might be 6 or it might be 16, right? But it's in the standard range. So all I'm saying is it's not that in every case, if it fits, you're done there. But you're going to see some examples where it can be pretty helpful to take those median sentences to sort of calibrate our guidelines, because we're going from 14 offense gravity score categories to something like 36 or whatever number we end up with, but many more. So we have to figure out how to spread it around, and median sentence might be the way to do that in many of these cases. But when you get to the other 20%, then I think you really have to eyeball them and say, why is it that we're recommending state prison and judges are placing everyone on probation for that? Are we going to change the guidelines to get to what the practice is, or are we committed to saying that we really think we should be recommending this and there's other stuff happening that we can't control that creates the separation? So that's what you get paid for, right? That's your decision. So a couple of other details, and then we'll take a break. For offense gravity score assignments, as I said, for the prescriptive approach, we're going to think about person first in terms of the seriousness, thinking of OGS assignments as more serious if the victim is a person. And some of the factors the Commission has traditionally taken into account in giving higher values is the age or the vulnerability of the victim. We also have things like enumerated persons, like in the ag assault statutes, you know, the police or teachers or other enumerated persons. So there are aspects of the individual, whether it's the victim or it's the, the victim in many cases, that could drive up a sentence recommendation just from a policy point of view. And then the other thing is harm. You know, did this offense result in death or serious bodily injury or bodily injury? Did it, if it was injury, did they cause the injury? Did they attempt to cause the injury? Did they threaten the injury? So when you look at the ranking of offenses we have, those are sort of factors that are used to reduce or increase the OGS assignment. And then other things like, was a weapon possessed or used during the commission of the crime? And then, of course, if you look at sexual offenses, there's a whole sort of gradation in the statute about elements that are in play, right? Forcible compulsion and things like that. So all of those kind of factors come into the ranking of offenses, and they're appropriate for that kind of prescriptive approach where you're thinking about what's the policy framework. When we get down to property, then we think about what type of property, and we've always given sort of premium to homes, right? So adapted for overnight accommodation. And then below that are other structures. And then we think about automobiles different than bicycles, right? And then other properties. So you have a lot of sort of a rank order of property that we take into account. And we often think in terms of property of what the loss or damage is. So what's the value that we're talking about? Now, this is one of those things where we talked about this in July about sort of the difficulty with burglary. Historically, the Commission has split out burglary based on information, on descriptive information, on sentences imposed, based on whether it was a house or a person was present. But the order we did was the highest was house and person present, then it was house, no person present, then it was not a house, person present, and then it was neither, right? And the last one was the F2. And so we gave house preference over person in that middle category. And at least for a couple of years of data, we saw just the opposite. And the opposite actually fits what we said our protocol was, which is person is more important than property. So you'd think that if you're going to rank order those, you'd think, you know, that the second category would be person, not a house, because of the fear of harm to a person. And as I said, there were a couple of years of data where that showed up. But when Matt did 3 years of data, what we found is it follows what we're recommending. So the second one is house, person, no person present, and then person, no house. So, sometimes the guidelines drive decisions and negotiations, and sometimes policy does. So we'll just have to see how this plays out with all of you. But right now it aligns. And in July, when we just looked at 1 year of data, it did not align. So, final category then is the public order one. So we want to think about the nature and extent of the disruption, whatever that might be for public order. And so when we think about things like drugs, we think about type or quantity of controlled substance. We think about BAC for DUIs. We think about role of offense. We think of culpability. A lot of other factors come into play when we think about how you would rank public order offenses. So all of this makes sense, but this would be our fallback. You know, we can use a combination of the two, but one of the things we wanted to make sure we thought about was in those cases where we didn't have any data and we couldn't use descriptive information, how do we decide how to plug things in? And so you have to rely on at least some kind of framework like this of rank order of seriousness. The final thing, or final two things we'll talk about this afternoon after the break is Matt will do an update on the prior record score. And as a reminder, in the past, we talked about reducing the categories from 8 categories to 4, to move from a point-based system to a categorical system, to really expand issues of lapsing so that stale records would be removed from the prior record score, and to reduce the overall impact of the prior record score, that 2 times thing that I talked about before. And then there's a lot of stuff we haven't done, but we got to work on. So one is completion of the OGS assignments, and today will be a big step in that direction. But we'll be looking for your insights for us to finish the work by December. One of the things we particularly want to look at is homicide, including murder 3. Well, you know, one of the things we've kicked around a little bit is we've, in our proposed categories, our proposed matrix, we have murder 1 and murder 2 separate because of the mandatory provisions and the other things that apply to those 2 offenses. And because murder 3 is all over the map and some of the penalties are really high, you know, one possibility is that we build murder 3 into that top category. We add a value or 2 so that at the lower end of murder 1 and murder 2, we add in murder 3 and provide a couple of categories that might address different aspects of murder 3. And then that would allow the rest of the matrix to be for non-homicides, or at least non-murders. And maybe you cap out at, you know, rape or IDSI of a victim less than 13, which seems to be about the highest type of sentence we see in the analysis. So more of that later, but we do want to think a lot more about how we address murder 3. We want to talk more about the prior record score analysis and determine how it plugs into the prior record score or into the sentence. You know, way back, prior record score only applied to the most serious offense in a criminal proceeding, and now we apply it to every offense. Was that a mistake? Was that the right thing to do? When we moved in that direction, we thought there'd be more containment because of concurrent consecutive sentencing, and that didn't seem to occur. So a couple of issues in tandem there we have to think about. We also talked about all these adjustments that we would do based on sentencing factors. We have to finish the selection and weighting of those, and then just general sentence recommendations. So it's a lot ahead of us, but today is primarily about the OGS work. And so I think we have ice cream and other stuff for a break right now. Unless there's any questions or comments, we'll take a little bit of a break. We come back and we'll walk through the offense gravity score stuff.
Hi,
Judge.
Mark.
Yes, Judge.
Yeah, I do have a comment. You know, back during the academic panel and in July, we talked about briefly, well, perhaps not so briefly, about juvenile records,
Yeah.
and how that impact the prior record score, and how adjudications are distinguished from convictions. And once a person becomes 18 and adult, those adjudications are viewed as convictions. So it's my hope that we can talk somewhere among the many things that we're going to talk about, what we can do about that, if anything, because it really has an impact in terms of the prior record score. And you mentioned sometimes it's tenfold And a lot of that starts when an individual is 16, 17, perhaps even 15. And when that person becomes 45, it really has an impact that is, well, it's conceivable, but I think it's completely fundamentally unfair because a juvenile, is told this is not a conviction, this is just an adjudication. But when that person turns 18, it's a conviction, and it has, in some instances, devastating effect on the incarceration and other considerations for penalties when the person is 18 and above.
Sure. Thanks, Judge. That's an important issue. We'll touch on that when Matt talks about prior record score. But I think we built in some recommendations. We may have to do more, but I think the way the proposals go right now is we have sort of some thresholds based on age. And so, clearly at 18, there's certain juvenile matters that don't come over to criminal court, that we don't include them in the prior record score at all. And then the next sort of break point is 21, where a number of adjudications would not be considered in the prior record score anymore, and then 25 and 28. And so by the time you're 28, I think under the current proposals, the only juvenile adjudications that may count are crimes of violence, but I think all others would not count. And one of the exceptions that I want to be honest about is direct files or certifications, because if you have a 15 or 16-year-old that is transferred to criminal court and then is convicted in criminal court, even though he or she is 16 years old, that is considered a conviction. So I think there's a separate issue about, is there anything differently that should be done for youthful convictions versus juvenile adjudications? Because I think we're going to try to do a lot on juvenile adjudications, but I'm not sure about the juvenile convictions.
Yeah, again, my biggest concern was not so much the juvenile conviction, but the juvenile adjudications, because it's stressed in literature and everywhere that adjudication is completely different from a conviction. But nonetheless, it turns out not to be that case after the person is convicted after 18.
Great. All right. Thanks, Judge. Well, Matt will cover that this afternoon. Judge Marsico?
Firearms charges are public order.
Chapter 61. So, and that's interesting, because that might be a carve out, because we talk about, for harm, we talk about use of a weapon, which could implicate firearms. So
right.
That's a really good point.
The community offense itself, the form of conduct offense, affects the resolution.
Right. One other thing that I should mention, and we skimmed over this, and we'll get to this in more detail later, but we're talking a lot about the offense gravity score assignment, and we're talking separately about the prior record score, and really reducing back to prior record score. But the one exception we've always talked about is that if someone is a repeat offender, that is a calibration, that's an adjustment we would build into the offense gravity score adjustment or assignment. And the reason we do that is there's a bunch of statutes that's built into the grading of the offense, the second or subsequent offense. But there's some that aren't, and we should be treating them similarly. So I think especially when you think about VUFA and you think about repeat firearms offense, some of that has to be addressed with the OGS adjustment, and that would increase the sentence, not necessarily the prior record score. But I think you just raised a really good issue about sort of categorically, where do we put Chapter 61?
And I think you can't be, to your point about the burglary and robberies, even though they're under the chapter on property, you can't always be guided by the heading.
Right, exactly. That's true. And so that's where I think, we're just, it's a macro kind of thing.
Right.
But, and because clearly the lesser offenses in like the burglary statute would still fall on property. But I think you have to always recognize if there's a victim, that's a primary thing. There's a person, it does that. So thanks, that's a good clarification.
so we're back from the break, and we're going to continue the policy meeting this afternoon. We're discussing the sentencing guideline review, I think specifically the prior record score. So, Dr. Kleiman.
Great. And so in Mark's introduction, he talked about one of the principles of the new set of, or the proposed guidelines, and that is the narrowing of the ranges and increasing the number of OGS categories. So we thought it would be useful to take a look at one of the existing OGS categories, in this case, an OGS assignment of 8, and see how the median sentences would play out for the offenses that are within OGS 8, and how that corresponds to the new proposed grid and guidelines. So just as a starting point, for OGS 8, this again, a reminder, all of our analysis is done for prior record score 0, and this is, in this example, going to be using the 3 years of data, 2017, 18, and 19. The standard range is 9 to 16 months, and the aggravated mitigating is plus or minus 9 months. So we would go down to RS to 25 months for the aggravated and mitigated range. But for now, thinking the standard range of 9 to 16 on the current grid. So this is Exhibit 3 in the packet of materials that was provided to you. And I'll be showcasing and walking you through, so you don't necessarily need to have the handout in front of you. So focusing on our first row here, this is all current offenses in OGS 8. So there are 1,700 offenses, 2017, 2018, and 2019. And this is for most serious offense in a criminal incident. So it's a reduced subset of all offenses by reducing it to the most serious offense in the criminal incident. And the median for all the current offenses is 9 months, which corresponds to our proposed OGS category of 17. So one thing to note already is that the median is equal to the lower limit of the standard range for our current grid of OGS 8. And as we work our way down, these have been sorted in order of the proposed OGS, and we could see just by these two examples here, this is homicide by vehicle with a DUI conviction and involuntary manslaughter, a victim less than 12, versus a felony 3 is the grade, and the second is a felony 2. The sample size for these are not tremendous, so there's 14 cases of the first and 21 for the second. But there's a median confinement of 16 months and median confinement of 12 months, which fits them into our proposed category of OGS 19. As we work our way down here, we could look at an aggravated assault, attempt to cause bodily injury with a deadly weapon. There's 378 of these cases, and the median is 9 months of county confinement, fitting into our OGS of 17. So we see that there are some, within this OGS 8, as Mark was defining the different elements that would cause severity, there's here causing bodily injury and manslaughter. These are some serious cases. And we have some that are above the OGS 17 of the entire range. And then as we work our way down the sheet, we see that there are some that start working their way below that, or it's still equivalent in this case.
Hey, Matt.
Yeah.
Could you back up to the previous slide?
Sure.
Just a question for members. We talk about serious bodily injury versus bodily injury, and we also talk about the difference between causing or attempting to cause. And when we're dealing with serious bodily injury, under the guidelines, we separate those out. So causing serious bodily injury is one OGS, and attempting to cause serious bodily injury is one less. When we get to bodily injury, we combine them together. And in statute, they're generally combined together too. So it's either attempt or cause bodily injury. And so just one question for members, and especially for the judges, is does it make sense to sort of follow that same design by separating out attempt and cause for bodily injury like we do for serious bodily injury? Or are there other issues in play that for bodily injury, it makes sense to keep them combined?
Yeah, Mark, I think it makes a difference. I think there should be a distinction between an attempt and the actual causing of bodily injury. But a separate question, what's the significance of, in the involuntary manslaughter, over or under 12 years? And what's significant about the age of 12?
I think that's a statutory provision.
I'm sorry?
Yes, I believe it, and it might impact the grade. I think the grade is higher when the victim is under 12 years of age. Ryan, do you have that's correct. Is that correct?
Okay.
So I have a question. When we talk about delineating them for OGS assignments, if it's a plea, they're going to have to plead to basically, it's like, not only a plea to a simple assault, or is the judge making the determination if it's a plea to a simple assault? And if it's a jury trial, are they required to make that determination?
That's a good question. It depends. Well, it depends. So the first thing that it depends on is whether it's an element of crime or not. And so you're absolutely right. If in the definition of the offense, that is an element, then that's a jury decision or the court sitting as, as prior facts. But for guideline purposes, if it's not an element, then the commission can subcategorize, and then the court is making a determination at sentencing based on a preponderance. So in the case of, that's a difference. I believe under the ag assault statute, I believe there's a separation between attempt and cause serious bodily injury. I think that's an element. I think there are two different elements. Whereas for bodily injury, they're one element. It's attempt or cause serious bodily injury. So you could prove either, and it's the same in terms of the grading and everything else for the statute. But the commission for serious bodily injury provides two different OGSs. For bodily injury, it's a single one, and if we separated them out, then that distinction would be a call for the court. It would be a court determination based on preponderance. Now, it doesn't mean that the parties couldn't negotiate to that if your county allows sentencing negotiation, but it would not require a jury determination.
Now, what was your proposed OGS of 17, the top one?
The top one there is the aggregate of all OGS 8s based on the median of 9 months for all 1,700. So it's the aggregate of all the ones that are listed underneath it. So just in generic terms, without subcategorizing all the other offenses into OGS categories.
And the 17 is 8 to 10 months proposed.
Correct. Yes.
But then it jumps for 19 to, if you go down one, to what was that? The homicide by vehicle, 12 to 18. Okay.
Yeah, and so just something to clarify from our last meeting, we were talking about whether or not to pick the lower value, like how to make the assignment of the OGS category. So in this case, it's 9 months. 16 would be 7 to 9, and 18 would be 9 to 11. So we were talking about which one of them to pick, and what we've decided to work with based on the recommendation was to use the midpoint one in this case, where 9 months fits within the midpoint. And if there is a decimal, let's say 11 and a half, we round down to the midpoint of that. And there's an example later of that, but that was just one of our decision criteria for these selections based on the medians.
Yeah, and just as a reminder, as we're getting back into this, the current OGS 8 is the equivalent. If you just look at the ranges of the guidelines, of the proposed guidelines, it's the equivalent of OGS's 19, 18, and 17 combined. So OGS 8 equals OGS 19, 18, and 17 in the proposed thing. But what you're going to find is when we take the data from all of the OGS sentences, they not only fit into 1918 and 17, they fit the whole way down to 6. So the sentences being imposed with a recommendation of an OGS 8 are resulting in sentences that we would give, median sentences, that we would assign an OGS 6. So Matt's going to sort of walk through these, but just so that you know, once you get past 17, we're below the guidelines. The median sentences are below the current guidelines.
Exactly. So this is giving a little bit of merit, if you would, to why we are disaggregating these broader OGS categories, because we have a blend of offenses that may not be that similar, or our range is so wide that we're including different sentences within that same OGS. So for the possession with intent to deliver, we have cocaine, heroin, and methamphetamine. Interestingly, they all have, for 10 to less than 50 grams, the same median months of 9 months, with reasonable sample size of 90 to about 175. And that fits them also into this proposed OGS category of 17. We'll take a little deeper dive into some of the things that Mark and others were talking at the last meeting about weights and how to be thinking about drug classifications and what our OGS assignments should be for different categories in maybe 2 modules from now.
Question, Matt, on that, just to jump back, homicide vehicle DUI conviction, I thought there was a mandatory 3 years of it.
There is if you prove the nexus. So there's a specific statute that allows for the nexus, but under the guidelines, even if you don't prove the nexus, if they're in the same criminal incident, we have an enhancement.
Mm-hmm.
And also just to jump
Okay.
in, the data we used excluded mandatories or enhancements, prior record score 0 only.
Yeah, that's a good point, Diane. We were trying to make sure these were really like pure cases. So we got rid of the extraneous stuff so it wouldn't impact the sentences that were imposed.
The PWI heroin over 10 grams threw me off because there's a mandatory for that.
There's a mandatory, but it's a notice mandatory. And so if the DA didn't give notice, then it was sentenced without a mandatory.
So you only looked at cases where the mandatory was not imposed?
That's correct.
Okay.
And we can look separately, and we will when there's enhancements or mandatories or other things like that. But we're just looking at like pure cases because we're looking at the initial assignment. But then we can build those other things in.
Yeah, I think you need to before you assign an OGS. You have to look at the entire universe of the case.
Right, and that could be one of the adjustment things. And when Matt does the drug offenses, you're going to see, we talked about this last time, just different ways of looking at it. And another layer that we'll have to add is what about enhancements, like school zone enhancements or mandatories? But you'll find that they're actually not used that much. The more common thing we found with the mandatories when they were in play was that they were used to negotiate pleas and to negotiate sentences, but not applied. And so you'd have a handful of them applied for drug trafficking, but more often than not, they were just like used to negotiate.
All right, so the last 2 here on this page are really to get to the point that Mark said, which is we have a band here of proposed OGS categories that runs from OGS 6 all the way up to 19. So we have these 2 firearms sale and transfer. One is materially false written statement. The other is material false oral statement with receiving a probation sentence, in this case of 38 months, and the second one being 18 months for probation. This is one where there is only 7 cases, so thinking about the assignment here, if that is an appropriate assignment, thinking if it should be closer to the one above it is something that gets to the distinction between descriptive and prescriptive as we take a look at these. Just to remind you, using the 2 here from the firearms, that we are looking, ultimately at this distribution of cases. If we remember, the standard range is 9 to 16, so for OGS 8, So there's clearly a lot of sentences on the probation side of this, and getting to Mark's earlier point about thinking of the combination of conformity to the standard range as well as the median sentence might be these two case types, and this one with a smaller n might be ones we might just want to take a little bit more closer look at of what the median is suggesting as the OGS assignment, and then taking into account grade and other similar offenses, current OGS assignments, and so forth when we're making this kind of assignment, especially again when we have the low end here. But I think at least with 7 cases, we have a little bit of confidence that the sentence is probation as the sentence type here. Okay, so just this first module was really to suggest or reinforce the idea that there is some value of expanding the number of OGS categories. We're going to be able to group more similar case types or offenses together because we have narrower ranges. So again, we would fill a space with these between 6 and 19, where all of these were currently in our OGS category of 8, with a standard range of 9 to 16, with that aggravated mitigated range from RS to 25, which is a lot of real estate with, as you can see, a lot of different offenses, maybe not of the same type within them. So Mark already talked a little bit about burglary, but I'll just want to walk you through. I think that the landscape here is, particularly since we spent a lot of time on it in our last meeting, just what the implications of adding the 3 years of data. So previously, as Mark noted, we looked at data from 2019. We saw a number of case types with very low ends or sample sizes, so we decided to use 3 years of data to get a little more confidence in laws of large numbers. So we have 6 different burglary offenses here, and as Mark noted, the distinction is whether or not it was a home or not a home, was the person present or not present, was there an attempt or a threatened bodily injury, and was there an intent to commit a theft of a controlled substance, are what is differentiating these types of offenses from one another. So just very quickly, because we went over this last time, but if we looked at 3502A4, which is not a house, no person present. This is currently an OGS 5 with the standard range of RS to 9 months. This was our distribution when we only had the 2019 data, just as a reminder. And we came up with a median sentence of 4 months of county confinement. And when we impose the standard range on that, we get 77% fall between that RS and 9 months. We get another about 10% when we add the aggravated range to that, and then we have a few upward departures. But our N here, or our sample size, was 161 offenses, which is a fair amount. We would have a lot of confidence in that, but that's only for 1 year worth of data. It's also worth noting in this that we had, and we kind of talked about how these distributions can have sentences that are more common. In this case, there's kind of 3 modal sentences here, greater than 36 months probation. We have 6 months and 9 months county confinement. So when we now add the additional 2 years of data, the first thing to note is basically we went from 160 times 3 is, in this case, 497, about 3 times the amount. And our median goes down slightly. It goes down to 3.5 months instead of 4 months. If we use the current standard range, we actually increase the number of cases that are within the current standard range to 90%. And we would fall here into our new assignment of OGS 11, which is 2 to 4 months. Again, as I mentioned, if you have 3.5 months, we're going to round down, so the midpoint is 3. That would give us our assignment of OGS 11. Oops, going back, sorry. So because of the narrow range, in current sentences, it's a little less than 20% of the sentences for those 3 years fall within our new standard range. If we utilize the aggravated and mitigated ranges of plus or minus 2 steps, which gets us from OGS 9 to OGS 13, we now have 63% within that range. So just a couple, again, things to note, which is by increasing the 3 years, we have a more precise, the distribution is relatively the same, but a more precise median value for our first OGS assignment of considering it to be OGS 11.
Hey, Matt, back on that one. Just as Matt said, you see different spikes there in the data. And one thing the commission over time has tried to do when we see separate spikes like that is try to figure out like why that happens. And sometimes it's because there is a sentencing factor or there's some element that's showing up and that we can distinguish these, and that's when the commission subcategorizes the offense. So, you know, back in time when the commission first started its job, there was a single kind of burglary, and the commission looked at the data and saw these different spikes, and based on the different spikes, the commission was able to come up with these different categories based on house or person present. But when you look at this, we've already done that, right? So this is a category that's not a house, no person present. And the question is there anything we could learn about those spikes that would explain why, you know, some judges are giving probation and others are giving 9 months of jail? And if we found like a reason, that would be worthwhile building into the guidelines as a subcategorization, because then you'd have more focused recommendations. Similar person, similar sentence. But you just don't always have that. It could be negotiated plea, or it's Dauphin County versus, whatever. And so there's not always an explanation.
And for those who are here, and I apologize for the color choice, on the projected screen, you can't see the aggravated mitigated range. So if you look at the computer that Christy just turned, 2 of those 3 big spikes do fall within the aggravated mitigated range. It's just a 9-month confinement. So my apologies for the
You don't,
slide.
to your point, Mark, you don't break it down by geography, though. do you?
Well, actually, we did, just to try to see what the lay of the land was. So, for instance, when we did when Diane did all of the analysis for this, she did median statewide, and then she broke them into actually 3 categories. One was urban counties, the second was rural counties, and then the third was by itself, Philadelphia. And so we tried to see if there were differences. And the most power was when you found all 3 of them on the same page in terms of what the median was or whether they fit in the guidelines or not. Even though they might be spread like that, it was just, you had confidence that it was more about the facts of the case and less about where it happened.
Well, yeah, because that includes kids breaking in a pool concession
right.
stand
Yep.
as well as breaking in a business or something like that.
Absolutely right. And so, it's sort of the discussion of murder 3. It's like so many things can happen. You expect they're going to be across the map. And so you see it there. So there's sometimes we can't do more than find the middle point and say, start there and aggravate or mitigate if you want to.
Okay, so this is a little tricky, this diagram, but let me just see. I think it goes to Mark's point earlier that when we looked at 1 year data from 2019, and we had our rank ordering, that we had not a home person present was the median was about 9 months, and then a home no person present was getting 7.5 months, and the OGS, the current OGS for home no person present is 7, not a home person present is 6. But our sample was only 6 cases for not a home person present. So we were talking last time about descriptive versus prescriptive, partly because of the small sample size here. So when we add the additional years of data, the order of the OGS goes 5, 6, 7, 9, because we're up to 23. But I still think it's worth considering or thinking about or discussing, as Mark mentioned, what our rank order or prioritization is in regards to not a home, person present, or home, no person present. So even though the medians are reflective of these differences, is this an area for the prescriptive entering into the descriptive element, where that if a person is present should be valued more than a person not present?
Yeah, and in this case, you see the one is a total of 23 cases. So it's not a big number to start with, and we know it's fluctuated back and forth. But keep in mind, when the commission first developed guidelines, they did the rank order they did because the data at that time said second in order was home, no person. Third in order was not a home, person present. So that held back in the late 70s and early 80s, and that's how we first subcategorized. So over time, it sort of fluctuates back and forth. And so that's one of those things where if you had a strong preference, you could justify, based on sort of a calibration of seriousness, that you could put person ahead of home. But, at least you have data here that would move in the other direction. And it's a marginal flip, and, the recommendation's not going to be much different between the two.
I'd at least make it equal, if not put the person higher.
Right. And that could be, well, you're Solomon, you've solved it for us. There you go.
It doesn't have to be higher,
Right.
does it? It could be.
It doesn't have to be. It's just whether you think there's a difference. But you're right, it flips. So treating them the same would be another option.
Is that factor, is that strict liability? I mean, does the individual have to know their home?
I don't think so, no.
It's just,
We haven't talked about that. It isn't a requirement.
No.
so there's
But I
no
do feel
impact.
confident, at least, that most people who are burglarizing are hitting joints that don't have people around. If you look at the numbers,
Yeah, that's right. There you go.
I don't think they want people to be there.
Right.
Okay, so this is just a relook at that same, those two cases that were in the middle there, the home, no person present, not a home, person present. And I think it also shows what Mark referenced with the urban and rural columns, and we do see a difference in the median censuses. I'll just say, though, that for not a home, person present, again, we have only 7 in the rural. So another flag for us was when there were differences between urban and rural, and just thinking about should that be considered for the assignment. And here, while if we just looked at home, no person present, again, a majority are in urban, and the median is 6 months confinement, and then for rural, it's 7.5 months confinement, with almost a little over half of the cases. So we think that that our typical median of 6 months seems to be pretty good for that. That's pretty close. There's no red flags sticking out there. But this was just to illustrate one more time of that what position these two might be in, and I think we've addressed that. And then this was just for discussion purposes that we will still have case types, or offense types rather, where there are small n. So this is not a home, no person present with the intent of theft of drugs. And so we have one case is that 11.5 months confinement of the one case truly representative of the typical sentence that somebody would receive. It seems, again, if you think home, person present is a proposed OGS of 19, the second from the top, and this is a proposed OGS of 18, maybe it's a little too far relative to the others, which are 11, 12, 14. But again, we can, for these small ends, rely on some additional information to make better assignments, even though this is a felony 1, so maybe it's more consistent with A3. But
yeah, and one of the things Matt points out here, you'll see with some of the other examples he has, and that is looking at sort of a continuum of the same offenses. And some you might recall back when there was the recodification of the sex offenses, that, the General Assembly went through and just rebuilt the structure with this idea of this sort of continuum that you had, really severe, penetration, things like that, and you got down to indecent exposure. But there was this sort of systematic sort of continuum of seriousness of the offenses. And to some degree, when we split out a chapter of offenses or a section of statute, it allows you to sort of look at all of those as a package. And then that's where you can do some of these adjustments, because if you start by saying, okay, we'll take all the burglaries, we'll plot them based on the median, and then, we'll identify the ones that look sort of like outliers, especially if they're small numbers, and see if, what's the story we want to tell here? What's the policy that we're driving here? Or what just makes sense in terms of rank order based on those other factors? That's where you can then plug in those values. You sort of clean things up a little bit. And we can do that with drug offenses. We can do that with robbery. We can do that with assaults. We can do that with a lot of different categories of offenses where you're taking sort of the power of numbers to put in the basic assignment, and then you're filling in the gaps by just what makes sense. Where does it fit in? And then we bring that back to you to take a review of that.
So I think the purpose of the first module with the OGS 8, of course, was to showcase the medians, but to illustrate why it was important for us to be thinking about expanding the number of categories. And here was to take a refined look at what we've already done by adding these 2 additional years of data. And I think that gives us greater confidence in these point estimates of our median values, but still recognizing, like Mark just highlighted, that we are going to have to take a closer look when these are small sample sizes for offenses that don't occur very often. So moving forward and thinking about, again, as a grouping of offenses that we could look at and see if the rank order makes sense relative to one another, is to take a look at assaults and strangulations in one sheet. And this is in Exhibit 5 for those who are taking a look at the materials. So my apologies for the size of this one. So if we have an aggravated assault with an attempted serious bodily injury to a child less than 13 by an adult greater than 18, the information on the left is the current OGS assignment, which is OGS 11 with a standard range of 36 to 54. We see here there's only 7 sentences, but the median is 18 months, and we're assigning it OGS 20, 16 to 22 months. So again, with the smaller sample size, this may be one because of the serious bodily injury, that it may be more similar to the one above it, which is an aggravated assault with causing serious bodily injury, which is an assignment of 23 with a median 36 months of confinement. So I think we will probably use, again, the same strategy to be thinking about ones where this is two elements for us that we're considering. The median is outside the standard range, and then our sample size here is quite small when we're thinking about it. But one thing to note, I think it for the most part on this list, does follow some of what Mark's lead-in was talking about, that serious bodily injury will be above the bodily injury, and then there are some strangulations mixed in, but for the most part lower than the others, and then simple assaults in there as well. Okay, looking at the next one, which is an aggravated assault, attempted serious bodily injury to a police or enumerated persons. Current OGS assignment is 10, with a standard range of 22 to 36 months. This is another one with only 14 offenses in the 3 years, and the median sentence is 10 months confinement. One thing to note here is the urban-rural distinction of the urban is receiving probation as the median, and it is 60 months, but it is probation. And the rural is receiving 11.5 for county confinement. So this is an OGS 18 in our proposed matrix of 9 to less than 12. But another example where the median is not falling within the standard range, and this may be too low of a proposed assignment for this type of offense relative to the rank ordering. So I don't know if anyone wants to comment on some of these relative to the what these medians are? And if not, that's okay. I'll keep moving forward.
Sure.
All right, so this is a longer list of offenses. So this is moving down the list here now to simple assault, causing bodily injury with mutual consent. So this is a misdemeanor 3, and we have 11 offenses, and the median sentence is 0.1 months of confinement. So a couple things to note here for us is that in the urban, while again, there's only 6 offenses, the median is 12 months probation. And when we look at rural, the median is county confinement. So there's a little bit of a difference between the urban and the rural there. And we would come up with a proposed OGS assignment of 10 for this simple assault. And I highlight this one because if you look below that, there's a number of misdemeanor 2 and misdemeanor 1 offenses that receive lower proposed OGSs than this simple assault.
Wait, this has deadly weapons?
Deadly weapon. It does, correct.
You don't see many of those, obviously.
And this current OGS is an OGS of 1 with a standard range of restorative sanctions as the recommendation. So here it's calling for county confinement of a small amount of 0.1 months, but outside of the standard range of what it would be at OGS 1. So I think it is reflective of the severity of the bodily injury with deadly weapon. Okay, this middle section here is just a range of simple assaults and strangulation that all receive a proposed OGS of 7. And the current OGSs are from 2 to 4. And we see median sentences of 24 months of probation for all of these offenses currently. And I think there's a lot of, for the most part, consistency between urban and rural for these offenses. And these are offenses, especially the simple assault with attempt to cause bodily injury. We have 5,400 offenses for that. And that would be a reasonable reference point for the others to see if they're in a similar nature to that offense.
Is that attempt to cause and cause, or just attempt to cause?
Attempt.
If it's bodily injury, they're both.
Okay.
And that was the point I was making earlier
Well,
about
separate them
maybe we should separate them out.
And just to note that the blend of current OGS assignments of 2, 3, and 4, 2 is a recommendation of restorative sanctions, 3 is restorative sanctions to 1 month, and 4 is restorative sanctions to 3 months, but with a recommendation of 1 year probation for OGS 2 and 2 years of probation for OGS 4. So if we're looking here at the median recommendation is 24 months of probation, especially for those OGS of 4, it's pretty consistent with the current recommendations of the guidelines, at least for these lower level offenses.
What's your OGS 7 proposed?
OGS 7 is, I think it is 24 months.
the really, I think, important thing about this is the victim less than 13. So one of the things we talked about with person offenses was one of the provisions was age or vulnerability of the victim. And so you can see why, not only by statute, but by the guidelines, that gets a really high ranking, not only on the offense itself, but by the age of the victim, the vulnerability of the victim.
And I just don't know that I would separate if the 6-year-old victim
Right.
was, raped vaginally as opposed
Exactly.
to orally.
And would it be the reverse order? I mean, it's not that you.
I don't think they get separated.
I keep it all the same.
Right. And that could be that's absolutely a policy decision by the commission. And you can see, there's some substantial numbers there, but you don't know. And as all of you know, these are really difficult cases that you try not to go to trial because of putting a victim on the stand and stuff like that. So it's not surprising that you're going to see outcomes that are more sensitive to those trial issues or negotiated pleas, things like that. So yeah, that might be a policy override where you say both should be treated the same, and that's fine. So that's at the top high level, the current assignment of OGS 14, and it maps up pretty well. The next OGS assignment for these offenses is OGS 12, and you'll see the mapping across the other side, but OGS 12 now breaks into 3 separate OGS assignments. 27 at 54 to 66 months, whatever that number is, it's like an eye chart here, 26 of 48 to 60, and then that 25 of 42 to 54. So again, it fits the footprint, right? We're just sort of focusing the sentence recommendations within the existing sentence standard range. So that's a pretty good fit there at OGS 12. Then we move to OGS 11. Here's the one difference of all of the sex offenses where we see a separation between the sort of policy thing, the current guidelines versus proposed one, because of the median sentence. So you'll see that under the current guidelines, the standard range is 36 to 54. And if we just use the median sentence, the proposed guidelines would drop to an OGS 21 of 20 to 26 months. So it would be a substantial drop. Now, the question is, there's 62 cases, this is sexual assault. Is that an appropriate and correct assignment because the median is addressing sort of the typical sentence happening? Or is this a case where you have a policy override where you'd say, as you look at this offense, the assignment should be different because it's a felony 2 offense or it was an OGS 11 before? And one of the things that I think is helpful when you look at all of the sex offenses is, again, you can create this continuum. So IDSI and rape of a minor is going to be at the top of the scale. And you can come up with a systematic way of organizing this that's first built with these median assignments, but then you decide if you need any corrections, any overrides. And that's where a decision like this would come in place. Do you favor the median assignment, or do you favor adjusting it to address some kind of policy thought? So that's your job. That's your pay grade. So we'll just try to line it up for you and have you decide. So let's keep going. So now we're down to an OGS 10. You'll see a sort of a perfect mapping there. The medians line up. So our current guidelines are 22 to 36. The revised one is 24 to 30. And we're wash, rinse, repeat on a lot of these things. You'll see here's another section of 10, OGS 10, and you find others within a proposed OGS 11 because the median's a little bit lower. So you go from 22 to 36 to 20 to 26. And then this is the OGS 6, I believe. Yep. And you'll see, there's a number of different offenses that fall into that 3 to 12 category. And they break out into 3 parts with 3 separate assignments based on the median sentence. Proposed OGS 19, 18, and 14. But all of those fit within, or at least overlap, the existing standard range of the guidelines. So it's a pretty nice fit. If you're going to take guidelines that are really broad and sort of split them up into smaller, more targeted OGSs, this is the kind of model that sort of fits because you're separating out within the existing footprint and you're using the median sentence to do it. And hopefully, and in some of these cases, there's some pretty big numbers there to support it, relatively speaking. Now, there are some that are fairly small numbers, and so, is 9 in that top category sufficient to feel confidence that that's a good OGS assignment? I don't know, but that's the benefit of looking at the continuum of all of these offenses and figuring out if any adjustments are required. I don't know, this is sort of the same old thing, but there's another 6 with, again, 2 to 4, a little bit of an overlap on the lower end of the 6 converting to an OGS 11. So I think those were the sex offenses. Again, a pretty good mapping. If you think about that consistency between current guidelines and just refining it for the new guidelines, that might be the poster example of that. We'll switch it over to Matt.
Okay. Fortunately, this one's a little bit different in terms of presentation, so maybe it'll be easier to see, but we'll see. Taking a look now at possession with intent to deliver, and I think the judge's point was important that there's the no mandatories here and everything removed from that. So what we have here now is we took a closer look at different weights rather than what the current classification is. And there's a midpoint of 0. Things to the left are probation in green, and then things to the right in blue are confinement durations. So, for example, the first line would be 36 months probation. The second line is 60 months probation, even though we're looking left. And then the blues are going up in terms of confinement in months. We also have an additional data element here, which was just the percentage of confinement sentences for each of these weights. In this case, it's marijuana is the top panel, and then what the proposed OGS categories are to the right. So, and I wish I had chose a different color than this light gray, but hopefully you can see that. Those are the current ranges that the guidelines are based on. So, for example, less than 1 pound is our current OGS 3, RS to 1. 1 to less than 10 pounds is OGS 5, RS to 9. And then we have groupings from 10 to less than 50. And we did not plot, there is a category greater than 1,000 pounds. There were no cases essentially for these, so we didn't include it in this analysis. But so you'll see OGS 8 is between 50 to 100 to 1,000 actually, of 9 to 16, and the one in gray there, OGS 10, is for the 1,000 or more, just showing you the space. So as we looked at this, and it'll become clearer for some of the other types of drugs, I think, is we wanted to see if the data spoke to us in terms of a different way to cut, to develop our categories by potentially weight or by some theoretical structure or way to think about this. And at the prior meeting, Mark talked a little bit about the idea of, street use and people just personal consumption, sale to support your personal consumption, maybe like a mid-level drug dealer, and then if you would, the kingpin drug dealer type. And so as we looked at this data, you could see some breaks and groupings of the data. We have the first less than 1 pound maybe fits our low, where it's 36 months of probation was the median sentence. We have 1 to less than 5 having the same of 60 months probation. 5 to less than 25 are the shorter duration confinement. But I also think if you look at the percentage of confinement, those are both 57% are the confinement. And then the 25 and greater, despite having a little bit of small ends there, it doesn't seem like the weight makes a difference past 25 pounds. Maybe it does over 1,000. But thinking about the assignments here, and what I did was for just the assignments themselves, I chose the higher one of the two. And some of that was because of the higher sample sizes. So for example, 5 to less than 25, my proposed OGS is 11 of the 2 to 4 months. So in this example, because we have the maximum of 36 months of probation as our recommendation for OGS 9, 1 pound and then 1 to 5 pounds are the same OGS proposed assignment, at least for marijuana.
Why do you go 11, 10, 5 to 10, 10 to 25?
I'm sorry?
Unless I can't see it right, the proposed OGS.
I see, okay, because for 5 to less than 10 pounds, the duration is actually longer. So it is, maybe it's 2 or 2.5 months, whereas for 10 to less than 25 pounds, the duration is about 1 month, which would be the proposed OGS of 10. So it's based on the medians. And so I chose for that category the higher of the two, which was just the proposed OGS of 11, which would be 2 to 4 months. I'm just saying they're very similar, if that was your question.
I thought you were proposing 11 for 5 to 10 and then 10 for 10 to 25, but you're not.
No, I'm just saying they're so similar that I'm just going to have a new grouping, which is 5 to less than 25.
But in the past 3 years, when you looked at it, people actually were getting sentenced more for
Right.
5 to 10 and 10 to 25.
That's right, yeah.
But not a huge number of cases
Sure,
in there.
just
Yeah, but
funny
the
little
weight didn't
anomaly.
seem to really matter. If it was the other way, we might think about having a different break point. But since, it would seem odd to go 11 and then 10 for a higher
that was my
amount,
idea.
yeah.
And I sort of recall when we looked at the data for drug offenses generally, and we looked at all versus rural versus urban and so forth, and especially when you looked at Philadelphia, what you found was, you know, where you had really large quantities, it was generally in Philadelphia or an urban setting, which made a lot of sense. And generally speaking, those counties, urban counties or Philadelphia, tended to have relatively lower sentences for drug offenses generally. So where the quantities went up, the sort of departures below the guidelines also went up. And so in the more rural areas, you might find smaller amounts, but you'd find more serious sentences for them. So it's almost like this trade-off in terms of equalizing.
All right, so if we took a look at the bottom panel, again, the shaded areas represent the current categories for the OGS. So this would be less than 2 grams of cocaine is the first category, 2 to less than 5. So there's a lot of differentiation for cocaine in terms of the OGS assignments based on weight. And then we have 5 to less than 10, and it goes 10 to less than 50, 50 to less than 100, and then I believe it also has 100 to 1,000, and then greater than 1,000 would be the OGS of 13. So when we look at the data, it seems to me that, again, we could group these into similar sentence lengths or durations, that there is a distinction of less than 1 gram, but between 1 and less than 5 are quite similar, between 5 and less than 10 and 20 up to 25 to less than 50 are quite similar, and then likewise for the highest category. So we could reduce, I think there were 7 current categories down to 4, if we think that those median sentences are giving us direction in that the weights are quite often similar in practice of what sentences and durations, the medians that people are receiving. So the proposed OGSs would go from 10 to 11, 17, and 21. And I think, again, we were guided a little bit for that middle category by the confinement percentage, percent confinement, even though it's not perfect, with 2 to less than 5 receiving 71% confinement, same as 5 to less than 10. But the duration is certainly longer for that 5 to less than 10. So far, does that approach seem, we're just, because we looked at more weights than are actually in the categories to see if there's natural groupings by weight. So Let me add on another layer here, which is taking a look at conformity by these weights. Happy the color choice, we can see them here, which is good. At the top, we have outside, below, within mitigated range, within the standard range, within the aggravated range, and outside above. So the green is the within standard range. So we superimpose our new categories on top of that. A couple things to note are, as we move down, it's most of the sentences are within the standard range until we get to about 10 to less than 25 pounds. And 10 to less than 25 pounds has the highest rate of within mitigated of all the weights, which gives extra evidence, if you would, to include that with the 5 to less than 10 pounds. That the current specification, judges are viewing that the standard range might be too high for that weight. And then similarly, we see that stair step for those from 25 to less than 50 and working our way up, that it gets greater in the purple as you go up in weight, suggesting that judges, as we see with the standard range, declining, that they're viewing maybe the sentences for those higher weights for marijuana to be more consistent with the 25 to less than 50. So I think we have some additional evidence by bringing in the conformity to the guidelines here. Okay, when we look at cocaine, I think we see a similar type of picture, giving us some additional evidence to look at where the mitigated is to suggest that those higher weights can be combined within those same, the new proposed categories. Especially when we look at outside below for those really high weights of 50 to less than 100 and greater than or equal to 100. We start seeing, one, the standard range declining, but that highest weight of greater than or equal to 100 grams, there's downward departures for those sentences for those offense types for those weights. All right, so before I move to other drug types, any questions about marijuana and cocaine, at least for what we're thinking would be an approach to, a descriptive approach at least, for defining categories based on weight, but that refines them. And I think one thing to note as we move to the next one is we're also picking similar weight amounts, at least in grams. The next one we'll have, I think it's methamphetamine, has up to 2.5 grams was their weight category, as opposed to here we're saying less than 2 grams. And these will be even cleaner examples coming up where I think the data, I mean, they're almost, if you would, identical. So if you look at meth PCP, the median sentences for less than 1 gram or less than 2 grams are almost identical. And that is a category, it's hard to see the way I did it, but that the original category is an OGS 6, and it's 2.5 grams, less than 2.5 grams is the first category, that's the gray on the left. And now we're suggesting that less than 2 grams, those sentences are essentially identical, OGS 11, 2 to 4 months. And we see that stair step of those proposed guidelines from 11, the next one would be 14 on the far right, to 17 to 20 to 23. And there are really discrete breaks in the data supporting the similarity, for example, of 10 to 25 grams and 25 to less than 50 grams. And we look again at the confinement sentences, 86%. We see a lot of, I don't want to use the word conformity, but conformity of the median sentences here to one another. And as we move down to heroin, a similar exercise where I think that we see smaller gaps between the sentences, but they certainly coordinate. For example, 1 to less than 2 and 2 to less than 5 being one category with the OGSs of 14, 17. The second grouping from the bottom of 25 to less than 50 and 50 to less than 100, we do see 19 and 18 Not sure, but this is a situation where the higher amount has a lesser sentence, so we're going to go with OGS 19 as the proposed OGS category. And then there's a big step up to that greater than 100 grams for heroin. And we do see that 94% of sentences receive confinement, and then it steps up to a proposed OGS of 21. So any general thoughts on this approach from a descriptive practice with a blend, a little bit prescriptive of saying if it's like that was less, we wouldn't have a greater amount, have a lower OGS, so we just keep it in the same category.
I like condensing the weights. I mean, there's way too many.
Yeah.
And I'm sitting here thinking, as this makes sense, as we sit here for hours and it goes through with color charts, is when we're having public hearings, my brain is thinking, how do you put this in a digestible?
Yeah. Well, I think one of the things Matt started with that gets to that is thinking categorically. So we're talking about weight categories and combining some of them, but also his labels at the start were about like low, medium, and high, and then like trafficking or whatever you want to call that bigger category. So separating out those two. I think the other thing in terms of combining them is also recognizing that that for each of those categories, although we're within the footprint of the current guidelines, we are bringing down the upper reach of that. So we are trying to promote, if you're going to incarcerate, it's for shorter periods of time. But remember, these would be overlaps with effectively our level 3, level 4, where we're talking about the trade-off for restrictive conditions of probation for drug and alcohol treatment and things like that. So I think there's sort of opportunities. One of the things that may be helpful when you think about this categorically, and I'd say especially for the low and medium category, is that perhaps we can build in something that allow courts some discretion in terms of role in the offense, dependency or drug treatment, and other things like that are taken into account right now, but we build it more directly into these categories. So that low and medium, we're really targeting for consideration, because there is a difference with someone like actively selling drugs versus someone just, possessing and using. And if in that middle category, you have two individuals with the same amount of drug and one is actively selling and the other is not, there should be a distinction, but I'm not sure we need to build it into the guidelines, but we should build it into the discretion of the court to say that's a factor that comes to like those categories that should be considered.
I agree. I don't know, practically speaking, how you can build that into the guidelines.
Right.
What we get paid to do is to
That's
say,
right.
okay, Mark's more a user, Tammy's more a
Well, yeah, we
dealer.
knew that.
Gotta pay for the shoes somehow.
But now I like the categories grouping. I gotta say, I think they're very low recommendations from the 5 grams up. I mean, and again, I'm relying on my past life as a prosecutor, but, we fought guys like not Todd, but his colleagues, and Craig at the time, to get, mandatory for heroin at 1 gram, because 1 gram of heroin is a hell of a lot of heroin as compared to, obviously, marijuana or cocaine. To make that a mandatory back in the day, and I realize where mandatories are now, but to tell me that someone could be selling 20 grams of heroin and not look at a state prison sentence standard range, that's insane. People are dying every day.
Yeah.
But
our governor wants to call, have an endless emergency for opioids.
Yeah.
And you're telling me I can't send somebody to state prison for that? I mean.
But my understanding is the reason it's not a state prison sentence is because when we're looking at what judges are actually doing, by and large, they're not giving state sentences.
I get that, but I think you got to combine the policy with what's happening. I don't think you can just look at what judges are doing. And we're looking now in a vacuum without the mandatories that were there for years.
I guess my question is, as a former prosecutor, trust me, and I understand myself, but I guess my question kind of becomes, and how's that been working for us? So I don't have better answers, trust me, but I also know, you know, we did the mandatories, we do early on, I had a huge drug case where I had 24 defendants on it, and it, you know, these people go away for decades, and then there's just, you know,
Right.
I don't, to say I have a solution, and I hear what you're saying, there has to be consequence, but hopefully.
I mean,
that's
one thing to
well
note is
researched.
that the aggravated sentence would be 2 steps up, which would be 12 to 18. So it would be within the aggravated range to go to state confinement. So from that 8 to 10 starting point there.
And
So
that's
2
without
steps up.
putting a reason on the record. If you have somebody,
Right.
you know, you can
Right.
go completely outside and.
And that's where I was thinking that if this is the starting point and you build into the consideration by the court, role in the offense or other things like that, purity of the controlled substance, you know, that's within the guidelines, an aggravating factor that doesn't go up on appeal. I mean, it's not outside of the guidelines. But I agree. I think, you know, one of the things about these data are that I think they're post invalidation of the mandatories,
Right.
because I think that happened in 16 or 17, right, in
Yeah.
terms of some of those cases. So mandatories wouldn't have been in play here. So this is a clear representation of what's
judges are
happening
doing.
right
Yeah,
now.
no, I get that. Yeah.
So, but you're right, and we should look more at the data, look at certain offenses, and look at the distribution of sentences to see what's happening, because we're taking the midpoint, and maybe it's, you know, that you have a lot of really high ones and a lot of really low ones, and we have to look at, can we subcategorize in some way, because that might get to the issue you're talking about. And maybe it's role in the offense, and maybe that has to be a factor, but I'm not sure. But that is how, you know, some guideline systems would try to split that out, where they'd have the court make a determination on role in the deal. You know, were you the middleman or mule versus, you know, whatever, and or other aspects in terms of, were you actually selling? You're in the middle category and you were actually selling, as opposed to you had, you know, the Walmart version of, you know, whatever the controlled substance was. You were buying in quantity for your personal use or sharing with your friends or whatever.
No heroin addicts buying 25.
Yeah.
So, and I get heroin, I mean,
I think heroin and meth.
we all work together on the less than 1 gram. I remember that. And look, fentanyl's even worse.
Right.
And we haven't even talked about fentanyl. So I get it, but I think trying to think in terms of a categorical approach, and also trying to think if there's things that separate out.
The devil's in the details.
Yeah, that's right.
Yeah.
And I think cocaine's going to be different than heroin, different than fentanyl.
I think heroin and meth are 2 big problems with that facility.
Yeah.
So largely this, I'm sorry, I missed a lot of it, but I mean, largely this exercise is focused on what judges are doing.
Yeah.
How do we contemplate as a legislative agency what the legislature has done in a lot of these areas? I mean, to Ed's point, I mean, the legislature, I mean, we've looked a lot at heroin and fentanyl.
Yeah.
And honestly, if judges aren't following our lead on it, then I don't know that should be dispositive for what we do either.
Right.
You know, I think that, I'm not saying that we shouldn't consider what judges are doing, but at the same time, I don't think we should ignore the sort of public policy discussions and votes that the legislature has cast, and even bills that have been signed into law, you know, regarding some of these particular offenses. So where does that factor in, I guess, is my question.
Well, I think with these other things, like we said, there's going to be policy overrides, and you have to decide when you think it's appropriate to do a policy override and when you think it's important to sort of look at what's happening and have the guidelines sort of reflect common practices, because that leads to uniformity and proportionality, all the stuff we're talking about. So it could be that you say, you know, opioids is a carve-out. we're gonna treat those differently than we're gonna treat these drugs. Or there's some threshold where you say, below that, we're gonna be creative and, really promote treatment and things like that. And above that, we take a different approach. So I think, you certainly can do that. And that's that whole sort of, when is it descriptive, when it's prescriptive, and I just think that if you come up with the categories, that's a good first start. Figuring out what the threshold of it is, if it's heroin versus cocaine, is a big deal. And then I think trying to see if there's any factors that we can objectify, because that's worked well with the guidelines where we're able to say, this distinguishes this case and therefore it's worth more or it's worth less. And so that's why I was getting at, is there something we can say about mid-level dealers or mid-level quantities where rolling the offense or drug dependency or other kind of factors are adequate to subcategorize, to say to judges, if this is the case, go high. If this is the case, think about problem-solving courts, or think about treatment, or even think about probation or jail rather than prison. Because, and I think pulling down the statutory, the maxes on the recommendations in those lower categories give you more flexibility or more guidance there. But as the judge said, you can also go 2 steps and it's still an aggravated sentence. You don't have to provide reasons except to us that we ask for them so that we know what you're doing. But
at what point, I guess, how deferential should we be to what's frankly codified in law? I mean, to Ed's point where you have, Judge Marsico's point, where you have, where the legislature and the governor have said, look, this quantity of this drug is worth this, or, look, a robbery with a firearm is worth this.
Yeah.
And that's what it ought to be. Where there's a state law that says that, how?
You gotta get those mandatories passed again, Tom.
Well, no, but the reality is, look, it's the judge who invalidated the mandatories, but it hasn't. There hasn't been a subsequent, rescinding of them by the legislature, and so, and look, these are not mandatories; they're discretionary, and we all know we talked about the aggravated, mitigated, all those other factors that are in play. But I guess I'm wrestling with, as a legislative agency, where the legislature has clearly adopted positions on some of these things, is it appropriate for us to go ahead and come up with something different?
Well, it seems they've adopted 2 different things. I mean, because the legislature not only has, you're right, has encouraged or has increased penalties on the one hand, but they haven't resolved the mandatory issue. And there is, we know the secret formula to reenact mandatories, and that hasn't happened yet. But I'm not saying you have to, but I'm saying on the other side, the General Assembly has talked a lot about treatment too, and problem-solving courts and other things like that. So if you think about the middle category there, the General Assembly has said both things. And that's why I'm saying there's some finesse about, if you have someone in a middle category.
I don't know if the middle category here are guys that need treatment, though. I really.
Yeah, that's what I was gonna ask.
I mean, don't.
I don't think in that middle category you're dealing with users.
Yeah.
That's a lot.
That's a lot.
The middle category in heroin is, 2 grams, right? The middle category
I was looking
in
at 5
meth.
to 10 in the middle. I'm 5 to 25.
5 to 25.
5 to
Okay,
25
so
is where I
that's
think.
the high category, isn't it?
Or middle.
Is it less than 1, the first category?
We have 1 extra, so it doesn't
Oh,
go
okay.
low,
Oh, I'm
medium,
sorry.
high.
Okay, sorry about that.
Yeah.
What's your definition of middle?
Yeah. Right. Which middle? Okay, I see what you
But I
mean.
mean, but people with that amount, that's not your.
Right. Yeah, that's not
Drug
drug
users.
users.
Right.
I've liked what I've seen so far with all the numbers from a defense attorney standpoint, but those numbers there look really low to me. I mean,
Okay.
I'd be shocked if I was representing a client who was caught with 10 grams of heroin and he was looking at a county sentence.
So, so if you were going to look at, let's say let's just look at heroin right now. So you see where the various lines are, right? And those track the data. So those track what we're seeing from judges. But that's absent mandatories, things like that. So what would you do instead? Forget about those bar charts. If you were going to have low, medium, high, and super high, right? Where would you draw the lines, and what would the thresholds be? Because those we can change any of this, right? There's no mandatories that require this. Statutory max is sort of pretty set on these 15 and 30 years basically, and so.
I would jump so you're using a 2-month jump for each one, then you get to 8 to 10. That's where I think you can make 8 and go to 6 months, at least go with 8 to 14 and then 12 to 18.
12 to 18.
I think there should be some consideration for a state sentence once you get above 5. And I think if you just broaden that a little bit to 8 to 14, that would make more sense. Now, then, if you do that, then you got to bump up the next one, which makes sense.
So the thing is, the stuff on the right, when you're talking about those, you're talking about those ranges on the right-hand side, right?
That's somebody with a 0 prior record score.
That's right. And so, with sort of the framework we're coming up with, those numbers, those ranges are locked in, but we can, bump up to the next level or next OGS category.
Right.
So I'm thinking if you look over to the left-hand side where we have the weight categories, where would you draw the line? If you're going to say low, medium, and high, and then, and you can have a threshold for what you think super high or trafficking or whatever you want to call it, corporate, but if you're going to say street dealer, low, medium, high, or street user, low, medium, high, what would low be less than 1 gram, or would it be a different threshold than that for the low category?
I'd like to hear from some cops or somebody that knows more about that, but again, heroin, most of your heroin cases are, you're fucking.
I know,
that's
right.
So, it might even be half gram or less.
Right.
Low.
And that's why we went from 2 grams to 1 gram on heroin initially.
Yeah, no, I think you're right there.
So then the next category is,
this is where I like your targeted 2 months.
Yeah.
I think 90% of the time.
Right.
But here's, I think, where it's problematic.
You might.
Well, and I know you can go up and down a couple things, but I just think from a public perception standpoint, sort of the Representative Stevens' point about the mandatories, I think 1 gram's a 1-year mandatory, 2 grams a 2-year mandatory for heroin. I don't.
Was.
Activist judges. But, to us to put out something that says you can have 25 grams of heroin and you're only going to do a county sentence, as opposed to, that's peddling death, let's face it, as opposed to somebody that burglarized something or did something. It just doesn't fit. And I just think with the opioid crisis, it is a really bad message. Right. And let's face it, drug dealers know, that, they know what they're looking at.
Yeah.
The good ones.
Yeah.
And they'll be like, wait a second, I can roll the dice and I'll just stint at the county as opposed to 5 years at SCI. And, they know that.
Yeah. And again, I appreciate the point, and we have to revisit this. I'm just trying to sort of get, from sort of the policy side, because we're seeing what's happening. So Representative Stevens' point is a good one, which is we're a legislative agency. We, based on that, if we were coming at it from a policy point of view, and we wanted to have 4 categories, but 3 sort of street level categories and 1 super category, where would that be? And if it's less than 1 gram is the low category, is the next one less than 5 and the next one less than 10? Is it something like that? And then we think about what the appropriate, assignment should be on the other side. Maybe it's not 3, 5, and 8. Maybe it's 3, 8, and 12 or something. I don't know, but I'm just trying to get a sense of like, where's the bright line where we say, these are the low, medium, and highs that we're going to sort of deal with some blend of options for courts to have discretion that sort of matches what judges are doing right now.
Yeah.
And then where's the break point where you say, no, these are, you know, big dealers,
I
and
think
these are
I'd like to get a little more
beyond
info
that.
on that. I mean,
Yeah.
I'd like to talk to some cops.
Yeah.
Wouldn't you
Yeah.
think like low would be a personal use person, a medium would be somebody who's maybe selling some to support their habit and
Right.
a little extra, and then high would be people who are, I mean, I'm just saying if we were saying, but I don't know, that's what
But how's that work out
that's
in
it.
the numbers?
Yeah, I mean, I don't know how many, I was saying how many bricks or gram, to which
Right.
Representative Stevens said, I don't know.
Yeah.
So that was probably
But
good.
that is, and these are the same discussions we've had over the years in trying to
Yeah.
think of what's the dosage? And then it's like, oh, well, we don't look at purity, so maybe, you know, purity matters. But, and then you get to fentanyl and it's, it's.
But you
man,
talk to
anything.
users, and they're just gonna say to you, they don't say like what percentage of this bag is fentanyl, like they're buying, and they're
Right.
generally buying, you know, bags or, what is a bag, a bundle, and a brick. I just
Right.
learned this because I tried cases. But, so, for a bag is just the one little baggie, and 10
Right.
is a bundle, and 50 is a brick.
Right. And
But-
that may be
But
part
some
of
people
the-
who testify that are drug users, they're like, yeah, I could use 20 bags a day,
Right.
20, 30 bags a day, and you don't, but that's mind-boggling, but that is, so I don't know. I mean, I agree with you, get more information, but,
Mark, do any states categorize it the way she laid it out? Because that's, in my head, fundamentally, that's how I've always sort of tried to compartmentalize
Right.
this stuff, like those three categories.
Mhm.
Are there any states that use that as opposed to using weight?
I'm not aware of it, but no, I'm not aware, but we can look. We can see what others do. But usually weight, regardless of the compound, is what most states do. So we followed the lead, or we've helped to lead or whatever in determining, in using that as the basis. Because then you don't get to purity issues and things like that, and you get to dosage or common usage. But one of the things that I think is less clear is, like, just the point you made, like, what is someone's typical use? You know, what's a use pattern? Because if you're trying to say, like, user, dealer, and then just super dealer, you know, what are we going to put in that first category? Because you're right, it doesn't take much heroin, but if you're using, you know, X number of doses, X number of hits a day, you know, it could be a larger quantity that you'd put in the low category for just use. And so that's the kind of thing that, you know, that's why I was saying if we're a little bit more categorical about how we do this, and we build into consideration that the court takes into account role in the offense or any other kind of factors, dependency, whatever it is, then you're taking advantage of the aggravated and mitigated ranges to sort of have that buffer. So it gets to what the attorney said in terms of having sort of a wider range. You're just more generous in thinking about or talking about aggravated and mitigated ranges as part of this, instead of just focus on the standard range, which is really tight.
Yeah, but that's what, in reality, that's what prosecutors and defense attorneys and judges do, is they really
Sure.
look at the standard range.
Yeah.
You know, we struggle with how to, you know, with the plea agreement that's in the mitigated range. Is the judge going to accept that?
Right.
And so, and I think judges are mostly trained that if they're going to go aggravated, they got to have good reasons to do that.
Yeah. And, you know, each county has different practices in terms of what's the going rate. And, you know, I don't know if this is influenced by urban versus rural counties. We can look at those data and try to figure out, but certainly as it gets in larger quantities, it's more influenced by urban counties, and particularly Philly.
Is there a way to determine how many of these sentences were influenced by cooperation?
No, but that would be, you know,
I would love to know that.
Yeah, I mean, how many of these
Sure, a
are
lot
plea
of that is.
negotiations,
Yeah.
right?
Yeah.
Well, keep in mind that, you know, 95% of what we see are negotiated pleas. Now, are they negotiations to the conviction or to the sentence or to
You don't know,
both? It depends on the county. But, you know, it's it's rare that we have like open pleas. So they're just not.
That's a great point. I would bet this is strongly influenced. Somebody has that much cocaine or.
The cooperative.
They're cooperative.
They are cooperative.
Yeah,
They're
right.
desperate, and that's
Right.
bringing these way down.
Just as a suggestion, because we could do this for forever.
Yeah.
Should we look at areas, because I think this flows along, whether you want to bump, burglaries, whether we say, okay, we like the breakdown, but it just inevitably feels low, so can we just bump the whole thing up a step or two, if that's the case? But the areas where, I'm going to say the stuff that like sits in our craw, sex offenses are always a hot button in terms of, for me, and domestic violence crimes. But the drug stuff, like what are the areas where we're going to be looking up? Prescriptive, I understand we don't have a lot of numbers, but also
Right.
prescriptive just from policy points of where there's reasons that we take consideration of more than just the numbers.
Right. Well, we got to where we are from a prescriptive approach. So these categories that we have were influenced certainly by the mandatories and any kind of statutory provisions, but also by commission members and cops and others that helped us to sort of come up with these categories and come up with these thresholds. So, there's a lot of justification for what we have in place based on sort of a vetted approach. The two things that come into question then is, or that are worth considering is, number one, have things changed? So we have fentanyl, that was new, we were just sort of experimenting, did we do the right thing, or did we overdo or underdo? Same with heroin and things like that. Are there changes that you'd make? And one of the other things is the disconnect with sentences, because whether there's a mandatory or not, mandatories do drive sentences. Absent the mandatory, this is what we're seeing. So and these guidelines are in place for this, right? So we could put the same guidelines in place and you'd expect the same outcome. So I'm not sure we're promoting anything, but anyhow, I'm just trying to figure out what direction we can take to simplify this, to take into account factors that may be important for consideration, and if there's a way of having a closer connection between what we're recommending and what's happening. Now, I think Representative Stevens is saying, let's promote change in the bench or promote change in sentencing by articulating what the General Assembly might be saying. But that's what we have been doing.
Well, except, let me just jump in for 1 second, because as I'm wrapping my head around this, maybe I should give more judges the benefit of the doubt. I don't think, if it seemed like when I said, I think these are the results of cooperation, there were a lot of heads nodding in the room.
Yeah.
So and I don't know, maybe the judges can tell me, if you have a cooperator, are they getting a mitigated range sentence? Because if that's the case, then what this is a mitigated range. This is what's being done in the mitigated range. So a standard range sentence shouldn't reflect this. A standard range sentence.
Or bottom guidelines.
So,
where they just play.
Yeah.
Yeah, I think, at least, a lot of what I see is, and here's what I think the problem would be. Those guys that are between 5 and 20 that we think are cooperating, they're getting that a county sentence now because they're looking at 36.
Right.
Okay?
Right.
So now you make that 8 to 10, A, they're not going to cooperate because they got no reason to, or B, if they do, they're going to get probation.
Yeah.
So, I do think with drug cases especially, the sentences are driven a lot by plea negotiations by people cooperating as opposed to.
You don't have cooperation in any other type of crime.
Right, so that's.
Right. You can't work off a burglary because you go and work undercover, generally.
Yeah, generally, yeah.
Okay,
It's happened, but.
so let's just talk about heroin for a sec. If we were going to rebuild this and we do it mainly building around the current guidelines, and we moved to try to simplify it in terms of 4 categories. So low, medium, and high. So let's say we take the, less than 1 gram, we do the less than 5, and we say the third one is less than 10. And then everything else is 10 or greater greater than 10.
Yeah.
Does that get to three appropriate kind of categories? Is there some adjustment you do there? Because then we can say, based on that, instead of using the median, let's look at what the sentence would be under the current guidelines and figure out what that OGS would be. And we look at sort of the two and say, what other kind of adjustments we do here? If we're going to go in that direction, at least it simplifies it, it sort of categorizes it. But I think then we have an obligation for like the low and maybe medium category to really think about how do we at least put in play consideration of these other factors in terms of role of the offense, were you dealing or were you not dealing?
I think that happens.
No, I think it does too, but the thing is, if one of the problems with our wide ranges right now and with not articulating things is that we get everything in there. And so in some cases, judges will think that, and that'll be a reason for going high, and in other cases, they'll think something like that and go low. And the idea is to try to narrow the ranges. And so I'm trying to figure out how do we narrow range appropriately, and if there are factors that we can articulate for either aggravating or mitigating, or for saying, because of this factor, we go in this direction. I mean, think how we do enhancements. We have sort of a starting point for those three categories, and then we say, if this is present, go up one or two. So instead of you having to aggravate or mitigate, we build it into the equation. And so actually dealing rather than just possessing bumps it up one or two, but we're starting at the same point, and then there's an aggravator that we build in by jumping up one or two, an enhancement. Or if it's, the person's drug dependent, yeah, but we're gonna have a whole menu of adjustments. And one of the things we can do as adjustments is if we can articulate some of these things that you think are important and matter in terms of moving in one direction or the other, we build it in as an adjustment that can be negotiated or can be agreed to. And then there's some certainty about what you're going to get out of it instead of just hoping the judge hits on that issue and aggravates or mitigates. Or as you were saying, maybe there's sort of the sense of you don't want to have to go into mitigated range, but if it's built into the guidelines, the adjustment would get you to the same point.
Well, I think someone, if it's shown that they're dealing because they're using, I think most judges are going to go, they're going to be willing to go to the mitigation now.
Because we're talking.
What I don't understand is if you got somebody that's, let's just say they're caught with 5 grams of heroin.
Right.
What more could you have to make it aggravating? I mean, what would be an aggravating factor at that point? He's already
Selling it to a minor,
or but isn't that?
Yeah,
but I thought, isn't that already in the statute?
Well, but we're going to build that in as an adjustment.
Right.
I mean, there's not a mandatory anymore for it, and we build it into the guidelines as an enhancement. Right. So that would be one of the adjustments that we would have in the guidelines. And I think, drug dependency or successful completion of, some kind of program or something like that might be other things. I mean, we're talking about building into the adjustments like substantial assistance like the feds do, or, other kind of things that would be mitigators. And I just think, we have a lot of offenses here, and there's a lot going on there, and if we can help to clean it up a little bit in terms of targeting things and identifying departures in both directions or adjustments in both directions, I think that helps us to get, better outcomes, and that's what we're supposed to be doing with guidelines.
But Mark, I don't know how you're going to accomplish reducing the categories and keep the narrow ranges.
Well, I think, one of the things is you'll have to pick or choose, right? So if you look at what we have right there, it's sort of what Matt was talking about. You look at the category of 2 to less than 5 grams and 5 to less than 10 grams. And, right now, the suggestion is that's 5 to 7. Well, maybe that becomes an 8 to 10, or maybe they're 2 separate categories, and the 5 to less than 10 is 8 to 10, and the 2 to less than 5 is, 5 to 7, or you bump all of them up. But it's just that you lock it in with a range, so you have a single value there, and then you think about whether there's some adjustments that we should have the judge make a determination on to increase or decrease the OGS. Because then it's not a matter of the judge or the parties mitigating or aggravating, it's that you've agreed, the court's made a determination of the factors present, like a deadly weapon enhancement or anything else.
If the standard range is 8 to 10, what's the plus minus then?
It would be 2 steps up or 2 steps down, I think. Depends where it is. So it probably gives you 2 or 3 months, right?
Yeah.
2 or 3
8 to
months.
10 would go to 12 to 18, and then 6 to 8 would be.
So, okay, well, you've given us something to think about.
Yeah.
No, look, we'll go back and, we'll be much more prescriptive in terms of coming up with some categories with some alignments that look similar to what our current assignments are. We'll try to articulate a handful of adjustments to see if they make any kind of sense and come up with some thresholds for those categories. And, get it back to you in terms of let's refining it. And we'll focus on heroin first, but,
Yeah, I think that's
we
okay.
have to do it. I think for the other ones, the same should apply, but the thresholds might be different and, certainly the recommendations might be different. But I get your point. And I think, we've always thought of the rank order as, at the top is fentanyl and carfentanil and all of that in terms of, micro amounts, micrograms, right? And then heroin, and then, meth and PCPs, depending on the part of the state, there's some pretty nasty stuff going on there, and some really,
No, I think that's that's a big issue.
And that's the problem from the trainings I've gone to. I'm no expert, I just listen to them on TV. But but meth is the one thing that in terms of your brain chemistry does some non-reversible stuff. So.
okay,
And then the
so,
last thing I just want to say
Yeah,
is really
sure.
quick too, because I bounced on both sides of this, is I love the idea of treatment and so forth, but it's also, as I say to people in front of me a lot, is a legion of water.
Yeah.
But a lot of people say they want treatment because they know that'll get them out of jail. A lot of people, but it's hard to. There are people that want it, but there's a lot of people that are, treatment's an excellent idea. People will, and I also understand treatment can take more than one time. I understand it's a bumpy road, but it isn't the panacea either. It sounds good always, but.
no, I like the idea. I like what we did in the 90s in terms of, you have a framework that has recommendations that are confinement or probation or whatever else, and you create a mechanism for a trade-off to treatment, and you base it on a clinical determination, and you fund it. You put some money into it, and I think that can work. And I think there's problem-solving courts that have great protocols in place, and you have to make it into the program. And I think in both of those cases, everyone knows there can be a pretty high failure rate, but I think it has to be part of the mix. And so this might be one way of trying to get to that.
The treatment courts work better than just treatment for the people who are high risk.
That's right. Well, but that's really the target, right?
Yeah, right.
For high-risk individuals for treatment.
I sit on our drug treatment court, but there's also a lot of failure. It's frustrating.
Sure.
Yeah.
After a year and a half, everybody, it's really going great, and boom,
Yeah. So I know it's 5:15. We have dinner at 6 o'clock. We did about a third of what we were going to, no, we got through a lot. We got through, and this has been really helpful. I really appreciate it. No, we'll roll over a little bit of this into tomorrow morning's policy thing, if that's okay, and then we'll try to at least identify some next steps to make sure we're on track.
All right, good morning, everybody. We're here this morning to begin our policy meeting. I think we're going to do a little bit of carryover from things we didn't finish yesterday with acronyms such as OGS and PRS. So with that, I'll turn it over to the Executive Director.
Great, thanks, Judge, and good morning, everyone. We spent yesterday afternoon going through an effort of an approach to assigning offense gravity scores. And we started by talking about two different approaches that are commonly in place. The approach we've typically taken, which is a policy-driven approach, which we call prescriptive, where the commission is prescribing a ranking of order and values in terms of seriousness and so forth. And then the other approach, often called descriptive, where you take sentencing data and you use that as sort of a marker or an anchor for assigning offense gravity scores. And because we are blessed with a lot of data, what staff did between our policy meeting in July and this meeting was combine 3 years of data to do the analysis of that OGS assignment based on the median sentence, the midpoint. Because during the last meeting, we talked about the median being the typical sentence, the midpoint sentence. And when we talk about typical, we think both about the disposition, so is it probation or jail or prison, and the duration, what's the recommended range, the standard range. Our guidelines traditionally have been very broad, and they sort of cross boundaries. So in some examples, we could recommend all dispositions, probation through state prison, and a really wide band of duration. And so one of the efforts under this rebuilding of the guidelines is to try to think much more in a focused way about a specific disposition that we're recommending, and then a tighter duration, so that we're giving more direction. This recognizes these are advisory guidelines. The other thing that we have talked about doing that sort of complements that is having a lot more offense gravity scores and using it similar to this federal system where there are factors that can be used to adjust the assignment. So you have a base assignment for an offense. We'd argue in a lot of cases you can do that based on the median sentence of sentences being imposed. And then there may be factors that are typical and common factors that the court determines to adjust that assignment, to go up 1 or 2, down 1 or 2, to take into account factors determined. And that's not unlike how we do enhancements right now. We have a base assignment for an offense, and if the court determines a deadly weapon was possessed or used during the commission of the crime, we have an adjustment to that recommendation. So we're just saying, let's look at other factors that we use in that manner to adjust the sentence recommendation. So that's sort of the framework that we're working within. Yesterday, when we started to go through the analysis of the data to say, well, if we use these median sentences as our initial assignment, how's that work? Well, we found that about 80% of the cases in Pennsylvania, the median sentences are within the standard range. So there's like real alignment between what the commission has recommended in the past and what the median sentences are. And what we can do by using the median sentence is sort of narrow the range of the sentence recommendation. Because if you have a range of something like, 6 to 16, but the median sentence is down towards 6, you could narrow the range to 6 to 10 instead of 6 to 16, and you achieve that narrowing that we're talking about. Or at the other end of the side too, at the upper end. So we're trying to figure out ways to use the data to help support the decision making. But what we found yesterday with possession with intent to deliver is there are times when our sentence recommendations from a policy perspective are totally different than the practice in the field. So yesterday we looked at recommendations we have in place for possession with intent to deliver, and then we looked at sentences imposed for those offenses. And there was a big gap. And so part of the discussion yesterday was, how do you reconcile that? Which do you go with? And the bottom line is, it's the commission's decision. But as was discussed yesterday, there's a need to at least consider the policy considerations. We're a legislative agency, and sometimes setting the guidelines is the starting point for negotiations, other things like that, that result in different sentences. So what we tried to do today, just sort of recapping yesterday's discussion, was to sort of go back to our current guidelines and see what kind of adjustments we could do to take a more policy perspective and see what that looks like. And part of this is just to sort of test the waters to see if staff is sort of where the commission is based on yesterday's discussions. If it is, and we did this for heroin because that was the focus of our discussion yesterday, but if this works or something like this works, if we have sort of a sense of the approach moving forward, then there are mechanisms in place to apply that same kind of thing to other drugs. So, if you look at the U.S. Sentencing Commission data, they have equivalency charts where they say, well, this amount of heroin is sort of equivalent to this amount of cocaine, which is equivalent to this amount of fentanyl. So I'm not saying that's the be-all, end-all, but that certainly could help to guide us in thinking about, well, how do we apply what we discussed today with heroin to cocaine or to fentanyl or to marijuana? So know that there are ways to sort of translate this to other drugs. So let me show you the slide. Oh, that's not it. Here's the slide. So yesterday when we talked about heroin, one of the things that Judge Bernstein raised was just sort of the packaging, just so that we have a common sort of language about what we're talking about. So, stamp bag is sort of the individual dosage, right? And that's generally about a tenth of a gram. And when you wrap 10 of those stamp bags together, it's called a bundle, and that's roughly a gram. Now, this isn't like regulated, so, so it's, we're talking rough numbers here, but generally a bundle is a gram, so it's 10 bags. And then a brick is 5 bundles. So a brick would be 5 grams. Now, one of the things to think about, and we talked about this, was like, what's a person using? Like, if they're buying heroin, like, what's their usage? Well, if you look at just DEA or other kind of sources of information, a low-level user maybe is using 2 or 3 bags a day, but it's not unusual for a person to be using effectively a bundle or more a day. So when we're talking about dosage, when we're thinking about what is the sort of typical use by a person purchasing or having heroin, 1 gram is maybe not a bad way to think about this in terms of that's a usage rate. And it might be more than that, but so thinking in terms of a bundle rather than a bag is maybe helpful for thinking about penalties or punishments, things like that. So that's the first category, just like what is the packaging, what are the terms we're using. The middle box are the sentence recommendations for the U.S. Sentencing Commission. And again, this is effectively the 0 prior record score. And it doesn't have any adjustments. This is their base assignment. And they have a category of less than 10 grams where the base assignment is 10 to 16 months. But keep in mind, the U.S. Sentencing Commission and the federal courts are a determinant sentencing state. So that's a flat sentence. That's effectively the maximum sentence that then is deducted by good time or earned time, other things like that. So our sentence recommendations, remember, are minimum term recommendations. The court's required to double it for the max and beyond that. And there's no right to parole, even though, especially for county sentences, that may be sort of a presumptive release at minimum. So we just have to keep that in mind, that when we're comparing our guidelines to the federal guidelines, we're talking different systems, and we're comparing minimum terms to effectively maximum terms. So something to keep in mind there. For the U.S. Sentencing Commission's guidelines, though, that lowest category is less than 10 grams, and it's 10 to 16 months. So they don't have, and this is the federal system, but they don't have, less than 5 grams or less than 1 gram. It's less than 10 grams is that lowest category. Then 10 to less than 20 grams is 15 to 21 months, 20 to less than 40 grams is 21 to 27 months, and 40 to less than 60 grams is 27 to 33 months. So it gives you some sense of where the feds are based on determinate sentencing, maximum sentence, some kind of deduction for good time or earned time. The third thing that I just wanted to sort of place on the table that we talked about yesterday was, even if we have a base assignment based on quantity of drug or type of drug, it's helpful to think about how we can use the system to build in adjustments. Because one of the comments raised by Attorney Marsico, and I think it's a really helpful one, is in terms of the difference between the court or the parties agreeing or trying to get the court to agree to a mitigated sentence or a departure below the guidelines versus building in the mechanics into the guidelines that the adjustment is made by a determination, just like with an enhancement, and it's built in so it adjusts the OGS assignment. And therefore, building in that factor could actually make that a standard sentence rather than a mitigated or aggravated sentence. It builds it in as another sentencing factor. It's like a subcategorization by the commission. So when you look at the U.S. sentencing guidelines, when you look at the discussions we had with the strategic planning work group and others, here are some of the factors you might think about as adjustment factors. The first is, just looking at A30 in the Drug Act, it's not just about possession and delivering. It's about, it's certainly about possession, and we're talking larger quantities where there's the intent to deliver based on, quantity and other things like that, scales, whatever other kind of indicia you have. But it could also be distributing it, not necessarily selling, but giving it to someone. It could be selling it. So there's different aspects, different actions that fall under the statute. And it could be that the commission thinks that there's a difference. We've talked about this in terms of culpability, recklessness versus negligence, other things like that, that some of these are all built into a statute, but maybe there's a benefit in sort of splitting them out for purposes of sentence recommendations. So the same could be true in terms of the action itself. And there may be a difference between possession versus actually selling it. So that's one adjustment that could be considered. There may be proof issues. There could be a whole lot of other things that create a problem there. But just one of the things that I think the federal guidelines at least anticipate, that there's a difference between selling and distributing from their point of view. Second is the role. Is this the kingpin? Is this a leadership role in some kind of drug enterprise, or is this a minor person on the street? So thinking about different roles and how that might impact sentence recommendations. The third is the substance itself, the purity of it, or if it's a counterfeit, because under our statute, counterfeit drugs carry the same weight as the actual drugs. And keep in mind, in our business, any substance or compound, whether it's cut with something else or it's pure, is the same. So we look at the weight of the substance or compound, and we identify the highest drug in it in terms of our scaling, and that becomes what we use for sentencing purposes. So keep in mind that if you have a stamped bag of heroin and it's tested and there's fentanyl, it now is fentanyl. It's not heroin anymore. So we're talking about situations where a stamped bag would be tested and it would be heroin as the highest ranked drug. And then there's other things that the feds look at, things that we've talked about before as part of broader policies, things like substantial assistance. And we talked about that yesterday, that might be a big part of what's going on with these sentences relative to the recommendations. It's the person providing information, substantial assistance to the prosecution, and so forth. But we know there's other things too, like, was a gun used during the thing? Well, we have a deadly weapon enhancement, so that would also blend into this. Were you selling in a school zone? Was it to children? So we have those kind of enhancements. Those would be built in as well as adjustments. The final thing that I wanted to put out there was the public health area. we spent a couple of years working with Vital Strategies looking at violations of probation and parole related to substance use. And we've talked a lot about the role of problem-solving courts and drug treatment and other things like that. So what is the role? How does dependency and treatment fit into sentencing, into adjustments? That's just another matter to add there. So these are a lot of factors that courts consider all the time. And the question is, do you want to sort of codify any of these? Do you want to look at the base recommendation we have and identify things that courts would make determinations in sentencing to, in effect, adjust the sentence recommendation? And to that degree, you're providing better data and information on what actually happened or what the court determined and having a sentence relative to that. So things for consideration. So now let's get to the magic below, the little table there. So I worked from Matt's table yesterday that he presented, and I put in place the existing sentencing guidelines. So the bands, the colored bands, reflect the current guidelines. So we have a first category for less than 1 gram. On the left, you'll see the current guidelines. So the standard range is 3 to 12 months. And if you add the aggravated and mitigated range, the full range for the guidelines is RS to 18 for less than 1 gram. And if you go to the right-hand side, you'll see a proposal that is based on using the anchor of that. So the base of the standard range is 3 months. So we use that range in the proposal, which is a 3 to 5 month range. And if you add the aggravated and mitigated under the proposal, the new range would be 1 to 7 months. The second category under our current guidelines is 1 to less than 10 grams. So those three are actually one category under our current guidelines. And the recommendation for that category of 1 to less than 10 grams is 6 to 14 months, mitigated down to RS, aggravated up to 20 months. So you have a lot of bandwidth there, right? You can go probation to state prison for that category. If you move over to the right in the proposal, again, we use the 6 months as the anchor, and that category would be 6 to 8 months. You add the ag and mid, and you go 4 to 10 months. So at least the thought process in putting this together was the two lower categories are really county jail sentences or trade-off with restrictive conditions of probation, problem-solving courts, intensive supervision, inpatient treatment, other things like that to deal with that. And you'd see that the quantities we're talking about are less than 10 grams. So less than 10 grams, again, we're talking about this is 2 bricks or less than 2 bricks. But if we're saying that a bundle or more than a bundle might be a person's daily use, it gives you some relative sense of what might a person have in their possession at the time that they're arrested, or what might they be purchasing if they have a substantial drug habit, right? So the idea would be these two lower categories would be what we described yesterday as low and medium. And they'd be primarily focused on the use of county jail or probation with restrictive conditions or treatment. And the idea would be in these cases, if there were adjustments like we have listed up there that were in a negative way, it would increase the sentence recommendation, right? If this person had a leadership role, if it was selling it rather than possessing it, if it was high purity, if it was, whatever else, the person wasn't providing assistance, you could see that there could be additional factors that the court identifies that might move it from presumptively a county jail sentence up to a state prison sentence. Because that's the third category. That would be the high category. So presently the guidelines are 10 to less than 50 grams. And our current recommendation is 9 to 16 months, going down to RS up to 25 months. And you can see that on the far side, the recommendation that I at least put there was a recommendation that is a state sentence recommendation. Remember, our new matrix has sort of these bright lines between county jail and state prison. So this purposely provides a gap between the middle and the high of 6 months and forces that third category into state prison. So under the current guidelines, we allow county jail or state prison. We allow probation and longer state prison as aggravated and mitigated things. This really focuses on this case being a state prison case. You can mitigate down to county jail, but probation is not in the mix. So it's a cleaner distinction that this is a higher level category. It's not a blended category like we presently have. And then I have like a really bright line because if 50 grams is sort of the threshold between what we say are basically street dealers or street users and something that gets into a bigger enterprise, then, you know, maybe that's the break point. And then we think about what's the right sentence for that top category. And whether it's a single category like 50 grams or greater, or you break it out like we've done in the past where we have multiple categories, and there's more that I don't have listed there. You know, the idea would be this would be a state sentence. It would be exclusively a state sentence. Even mitigated would be a state sentence. So we're you know, creating that doubling from the 12 months to the 24 month as the base, the standard range. And again, this one is you know, basically your call as far as what the appropriate assignment, and if one category is enough or more categories are enough. The final issue I'd throw into this is just recognizing the interplay between the federal guidelines and the state guidelines, because clearly for drug trafficking and things like this, there's a lot of, you know, cross designation, right? And there is movement of cases from state to federal jurisdiction. So when you get to the larger quantities, that's another factor in play that might not be in play with the smaller quantities in terms of who's going to, you know, is this going to be a case that goes federal rather than state? You'll certainly see that when you have firearms involved, but you could see it just based on quantity too. And so anyhow, this is just an effort to take what we talked about yesterday, instead of focusing on using the data to sort of plug in numbers, look at what our current guideline assignments are and use those as sort of a starting point for coming up with a new system, and then trying to come up with some separation between low, medium, and high, both in terms of quantities, but also in terms of the recommendations that are out there. And again, for the super high or whatever you call that final category, that's, you know, we could do more work looking at that, but trying to sort of figure out where's the threshold there, and does it make sense, or is it necessary to have a lot of different categories, or you basically just call it a high category, and for really big amounts, the court departs above or aggravates, does whatever. So with that, let me just sort of open it up for any thoughts or comments. It was just intended to sort of review and rebrand what we talked about yesterday and see if we're on the right path, and if any of these specifics make any sense, that can give us some guidance for how we look at the rest of the drugs.
I had a question.
Sure.
So the blue bars, I assume, represent, is it the median?
Those were the median confinement sentences under the current.
I hate to do this, too, but do you have those numbers for each of those categories?
We do.
I know you have them. I meant you have
The number of cases you'll see is under the second column. The N is the number of cases, and then the bars, you can see the first category is 12 months as a minimum term. But we can break that out in a little more detail.
What I meant was point numbers. Yeah, I don't know if Diane is on and she could read those actual numbers for us.
Point numbers in terms of the median
Like
sentence.
3 months would be for less than 1 gram.
I need to find it.
Yeah, and I'm sorry to put you on the spot.
Is it when you have the zero, like little, when it's over, I'm guesstimating that's about 3 or 4 months on the top. Does that make sense? Are those
What's that?
scale, the little blue squares?
Yes, those squares are to scale. So, clearly for like the 25 to 50, we're talking about 12 months or just less than 12 months. And for the less than 1 gram, you might be talking 3 or 4 months, right?
Yeah, I have it here.
Okay, thanks.
Less than 1 gram, 4 months. 1 to 2 is 6 months. 2 to less than 5 is 6. 5 to less than 10 is 9. 10 to less than 25 is 9. 25 to less than 50 is 12. 50 to less than 100 is 11.5, and more than 100 is 23.
Thank you. That's
Mhm.
great. Mark, you made the comment that under 50 grams, over 50 grams, you thought was a bigger enterprise and not a street dealer. So then the reverse of that would be that under 50 grams would be what's commonly dealt at the street level. What's that based upon? What's that, like, where's that, where do you?
Well, if you look at it, I mean, that's just a labeling we're coming up with, but if you look at the categories for the U.S. Sentencing Commission, and you look at just the breakout of the recommendations, you could argue that our recommendations right now, 9 to 16, again, we're minimum term there, maximum term, but it probably is somewhere between the 10 to 20 and the 20 to 40 gram categories. I mean, that would be sort of the equivalent that we're looking at there, right? So that's it. Like I said, I'm not sure where you draw the line there. I was just looking at our current guidelines have the category of 10 to less than 50 grams. So yeah, we don't have to characterize it as street, but it's just our current guidelines have that as the category.
I guess I'll make 2 comments, I guess, and then I'd like to just kind of hear the rest of the discussion. I think we have to remember we have an A16 crime
Right.
of simple possession.
Mm-hmm.
I mean, in every single one of these cases,
Mm-hmm.
every single one, without fail, there is evidence that at least some portion of these drugs were going to be distributed to somebody else.
Mm-hmm.
Or delivered, or whatever the word is you want to use, but they were going to go to somebody else in every single one of these cases. These are not simple possession cases. That's a whole different set of guidelines. And, so I worry about sort of and we don't know what the percentage is of these cases that are in that possess, distribute, sell category, and that possess, I don't think it's fair to put possess in there, because possession with the intent to distribute.
Right.
And there had to have been evidence of that in order for there to be a conviction here. So, I worry that we are, assuming a great deal of personal use here when we have a separate crime in the crimes code and a separate set of guidelines for personal use, for the personal use piece here. So that's sort of my high-level concern. The other concern that I have is that as we discussed yesterday, I happen to believe, particularly at the higher levels, but when I say higher, I mean it may even be the 2 to 5 grams and above, that what we are seeing in terms of the mean sentences are sentences after judges have given consideration for cooperation and other things. I'm removed from the courtroom for some time, but that was the practice when I was there for 10 years, and I haven't heard anything to suggest that changes, that when you have somebody who's coming in with weight, they're going to try to cooperate because of the fact that the guidelines are what they are. And I think that that's an important part of the overall criminal justice system that we can't lose sight of. And if we make dramatic reductions in the guidelines, I worry that, and we base it on the assumption that these are what I'll call, sort of
the run-of-the-mill standard regular case without cooperation, I think we'll be doing a disservice to the system in that regard. But
No, that's fair. And keep in mind, these proposals are linked back to the recommendations, not to the data, but they do line up with the data, you're right. But they were modified to make sure we were linking to the current guidelines. So the 3 to 5 purposely was picking the value that we have in the new guidelines at 3. And I get the point. I mean, we could look at the other end of the spectrum and we could say, let's do the upper end of the current recommendation. But I was also trying to differentiate especially the lower 2 categories in terms of use. And you know, what we talked about before, which is if you have a low category that's general use, the middle category is users selling or delivering to support their habit, and then a high category, and then the super high category, trying to have a distinction between those lower 2 categories and the upper 2 categories. So I'm good with, you know, however you want to approach this. I'm just saying that the intent was to try to link it to the current guidelines, not to the data.
so I get that and I appreciate that. I guess in the what I'll call the second level and the third level.
Yeah.
In our current guidelines, a point that I think is really important is that there is the availability of the judge in the standard range to give a county sentence or a state sentence.
Right.
And I think that drives a lot of cooperation and plea negotiations. And when you move over to what is proposed, particularly in that second level where there's 400 cases roughly, you know, if the standard range becomes 6 to 8 months, I worry that has a really heavy impact on just the way the system functions as it relates to cooperation and plea negotiations and everything else like that. I'd be interested to hear Doug's perspective on it too, as a defense attorney. But that's some of my concerns. Right now, those guidelines straddle that line, and I think that helps in a lot of cases, but I'm just one guy.
Your defense is going to be a lot less motivated to cooperate when they're looking at 6, 8, some kind of county sentence versus the state sentence. There's no doubt about it.
So my thoughts are, if you want to deal still, much like you said, there's always a possession that goes with this. And I agree with the plea and so forth, but I also know, at least in my county, how things are charged a lot of times. I mean, the argument for when you get to the lower numbers, there isn't always indicia. The argument is just that quantity is not for personal use. So I've seen plenty of those cases. There's no scales, there's no baggies, there's no paraphernalia, but the heroin. So, I mean, that's why I think these cases are all across the board. So when I'm looking at the proposed, I guess if you want that person to cooperate and the prosecutor wants that information, they still have the leeway to go to a different, or they can charge it as an undetermined amount as opposed to the amount on the criminal information. So there's all kinds of ways. If a prosecutor and a defense attorney want a certain outcome, there are plenty of ways for them to do it outside the guidelines. And if you look at I know that these are median and you're considering maybe but the way I charted this out, the median on the lowest end, the less than 1 gram, is 4, and they're proposing 3 to 5. That middle ground seems to be where people are the 1 to the less than 10, those 3 categories together. If you look at 6, 6, and 9 are the median now, so that's 6 to 8. So maybe that's the area where people are having a little trouble. But the next 2 categories actually bump things up from, I mean, the starting point for the standard proposed range is the high end of the median range on those, and then same with the last 2. We have 11.5 and 23, and our going rate right now is 24 to 30, and then we still have the adjustments. So, I mean, I guess what I hear is people are saying this stuff's serious, and we're not taking into consideration, but I feel like this, if anything, is kind of bumping it up on the high end, certainly when you get above the 10 grams.
I think you're right to an extent, but the other elephant that used to be in the room was the mandatories.
Right.
We're looking at this in a post-mandatory world, you know, and the legislature had said, you know, 1 gram was a mandatory state sentence. 2 grams, 5 grams, or significantly more. So, you know, I get why a lot of those sentences are lower, and I, you know, kept us here way too late last night speaking about this. Just a couple points is I like this. I think it's better than where we are. I think it's a good idea. I still think it's a little low, you know, with the guidelines based on, you know, and I'd like to get some more data on what's out there in, you know, various cities, various counties on, you know, in Harrisburg, somebody's got 8 grams of heroin. They're a big size dealer. And Doug, do you agree?
Yeah.
I mean, and I think, Mark, you talked about people selling to support their habit. That's not who we're hitting here with that 1 to 10 gram. Seriously. I mean, I don't want to, that's people that have a little bit and stuff like that. And I think most people, you know, most cases, those work out most of the time, as Todd said, to simple possession or something else. The other thing I think here, the adjustments, I got them all over. I don't know if I like complicating things more with sentencing, but I sort of like the idea. I will say this, though. I wouldn't distinguish between, as Todd said, you know, possession with, these are possession with intent, as opposed to selling. You know, somebody sells 1 bag as opposed to somebody that possesses with intent to 10 grams, you know, that possession with intent, that guy's a lot worse than the person that sold 1 bag. So I don't think you can look at it as selling's worse. Maybe distributing to friends that share, you knock that down. I don't have a problem with that, you know, as opposed to it's not for profit. You know, I think that's there. You know, the other adjustments, I think substantial assistance is a good one. You know, purity, I think, becomes difficult to just logistically to figure out in that stuff. You know, then am I going to be stuck having a hearing where someone's arguing, you know, we're bringing in a chemist and we're doing all that. You know, I'm not sure I like going down that road. But yeah, I mean, I think this is good. I think we just need to look at it and get a feel for it again. I was stunned by the data yesterday as to what's going on out there, you know, with these sentences, but it's post-mandatory. And as Doug brought up yesterday, you know, a lot of these are, you know, plea agreements.
Yeah. Well, to the chairman's point, one thought, and I guess the second category to me is already a pretty broad category. So, you know, I get that, you know, is the threshold for what you're talking about, Judge, you know, 5 grams rather than 10 grams,
I don't know.
something like that. And but that's the category we have right now, and that's the recommendation we have.
No, and I like how you did it today, matching it up with
the
current ones, which again, I'd rather condense those categories, but I think here you need
and so
leeway.
So when you get to the sentence recommendation for that category, if it was 1 to less than 10. You know, our approach is to try to pick a disposition. And so to the chairman's point, you know, what is that disposition? Is it county jail or state prison? And so I could see to get to the part of the concern, you know, bump that up from 6 to 8 to 8 to 10, because then a 1 or 2 step adjustment puts you in state prison. And that adjustment could be because of your role, or because you were selling, not distributing, or, you know, or any of those other kind of things could play into that. But it would be primarily a county jail sentence. And that takes into account what we're recommending right now. It moves them from 14 down to less than 12.
And I just texted a cop I knew to say, you know, in Harrisburg, what can you get? He said 1 gram of heroin is about three bundles to make up a gram. So that's going to be, you know, significantly different. That's going to vary place to place. And
like I said, not regulated, but So.
I have a question. For the adjustments, first of all, can they aggregate if you meet more than one,
Mhm.
and then what if you have offsetting?
No, that is part of it, because that's what the judge is taking into account. But in any of these, and in what we talked about general adjustments, it would be a combination of, you're in effect checking the box, pluses and minuses, and it is offsetting at times. But the thing is this moving more in the more severe direction or in the less severe, or is it just, is it basically in the mix because it's a mixed bag, which is not unlike what you decide, without checking boxes, right? You're balancing those things.
One thing I would add too, and I'm not sure where it fits in, but you're looking at the data, is that, cooperation happens before they're charged.
Yeah.
For the most part.
Yeah.
They don't want,
Mhm.
obviously, know the person's been charged if you're putting them out there. So, by the time they're charged, a lot of times the DA and the police officer are already worked it out. Okay, we're only going to charge you with this amount versus, so.
Well, but part of the thing is, and I hear that, but, we know there's different policies or practices from county to county in terms of, are the police charging and the DA's reviewing, or is the DA actually approving charges and things like that? And so, just by local rule, you have different practices. And I agree with you. I think if the DA is involved in the process before formal charging, I think those things are accounted for. Absolutely. That makes a lot of sense. But in some counties, cops are going to be charging whatever they see, and then the DA has to decide how to
These
deal
cops on the street, they know too. They know if this person's a user and a dealer supporting their habit. They know.
Yeah.
Can I ask any comments?
Sure. Yeah.
Are there any comments from anybody who's participating via Zoom? Okay. That was easy.
Ed, you were talking about a concern about distinguishing between.
This is Senator Street.
Hi, Senator.
How are you? How's everybody? Look, I think that I think this is generally speaking good work. The one thing I would say is that as we're making adjustments for, how we guidelines around drugs, I frequently get the question about when we are going to make the downward adjustments to marijuana for many instances in which the guidelines for things like DUIs and also are still pretty high, and in some cases, for some of the stuff they're higher than powder cocaine. And I just think that that's something, as we start talking about that, when we get to the point we're talking about this to the public, making these upward adjustments in some cases around fentanyl, which are probably appropriate, there will be discussions, and we should have thought about what, if any, downward adjustments we're going to make around cannabis, which people no longer think of in the same way that they once did when the original guidelines were created.
Thanks, Senator.
So, Ed, you were talking about a concern about distinguishing between possessed with the intent to distribute and then actually, delivery or distribution. What was that concern again? I wasn't.
Well, I said, I don't think you can have, selling be more of an upward adjustment than possession with intent, because somebody might just sell one bag as opposed to you might possess with intent, a significant amount. That person might be, the dealer who just hasn't been out on the street yet. They've got their stuff in and hasn't made it. So I think but I did say and you see this a lot with heroin, sharing, friends sharing, not selling, which is technically distribution. Maybe that could be a downward adjustment there because it's not for profit. I wouldn't have a problem, with that.
I wondered if in that middle, I'll call it second level there, if maybe there's some play with some of those adjustments where they might they might bump you up a level as opposed to
sure.
moving you
Absolutely.
up to an aggravated range.
Yeah.
And I, just looking, based on the data you had provided, that 5 to 10, I mean, that's either, 50 or 100 bags. So 50 or 100 doses
Right.
of heroin. It just seems like a lot for a recommendation of in essence, a 7-month.
Right. And
sentence.
again, we can, one of the conflicts is, we're trying to have fewer categories, but then you end up with a 1 to 10, which we already have, and it covers a lot of landscape, right? And so trying to sort of figure out which approach you take, and then recognizing judges are going to have discretion. There's going to be a lot of stuff that goes back and forth. One thing that I didn't talk about here, but it maybe is an example of another way to think in terms of adjustments is we have talked about building into the guidelines as a step up, step down, second or subsequent offenses, because that's a big deal with drug offenses because of the doubling of statutory max. So it's codified that way. And so, the expectation is you're going to be moving from whatever the base is to something higher because this is the second or subsequent offense. So that's going to be built into the OGS side. And maybe for drug offenses, instead of thinking about how many OGS steps do you do, maybe it's categorical. You move from low to medium, you move from medium to high. So we think more categorical that way instead of, because then it gets to your point. If we say you're in the low category, the less than 1 gram, but you're a repeat offender or there's these adjustment things, it bumps you to the recommendation for the middle one. It's not like go up 2 or 1 or 3 or whatever. It just takes you to the next level of drugs. And
sort of to that point, so in that second level, we're looking at, if I'm reading this right, your proposal would be 6 to 8, which would be 15?
Yep, that's right.
Okay. So now let's take it from a 0 prior record to somebody that's got, like would currently be an RFL.
Mm-hmm.
So that guy could have 10 prior deliveries or PWIs, and he's only going to move to 9 to 12 with 9 grams of heroin. Right. I mean, that's insane.
No, but again, and keep in mind, that's why we said second and subsequent for the same offense is going to be handled on the OGS scale by a stepping up on the OGS. And what I'm saying now is maybe that's categorical instead of by OGS.
So his second one wouldn't be a 15?
No. It would be whatever we decide is the number of step-ups, or you move from one category like low to medium or medium to high.
Is that for every offense or just for drug offenses?
It's for what we were talking about in the earlier proposals was for a same or similar offense. Repeat burglaries, repeat drugs, repeat others, because there's a lot of offenses, as you know, where the statutory max doubles because of a second or subsequent. So we build that into the OGS side. Prior record score would be general criminal history, and that would be excluded from it if we've accounted for it on the OGS scale. So if you have a repeat PWID, you're going to adjust the OGS, but you wouldn't include it in the prior record score.
I don't know if that complicates or simplifies it, to be honest with you.
I think it gives you a different scaling. That's the thing. Right. It allows you to scale it to get to, one of the issues I think you might recall during the strategic planning thing, DA Stedman at the time, Judge Stedman, was real concerned about persistent offending of similar types of offenses, burglaries, drugs, whatever else. And so as part of that discussion, there was talk about thinking about repeat offending for the same kind of offense differently as just prior record score where you have a criminal history. And so clearly for drugs, that's a huge thing because of how the statute works. But the other thing, just because it's important for drug offenses, is the stacking provision under the statute. It operates differently than the guidelines. So the guidelines, you have to have conviction before the commission of the crime for that to be included in the prior record score. But for the drug stacking provision, you just need both convictions and conviction before sentencing, right? So that's another reason why you want to move it over to the OGS instead of having it in the prior record score.
How would that work for like a retail theft?
Probably the same thing because you have the grading provision. But with retail theft, I'm not sure if that has a stacking or not. I'd have to look at the statute about it. If you have multiple retail thefts, I think you have to do, I think you have to have it, yeah, but I think you have to have the conviction before the commission. I think it's the old like Eyster rule and stuff like that. So, but there are exceptions, and there's growing exceptions where it's that stacking approach. So stacking's the perfect reason to have it on the OGS axis instead of the prior record score, because it wouldn't count in the prior record score.
Gotcha. It's a good start. I think we got to, no matter what, we're going to get information from others.
Yeah, and look, the idea of trying to get something that we can sort of, as a starting point for us, so that we can work on it for you, but also we're going to have public hearings and we'll hear a lot about, the flaws, believe me, we know that. But trying to figure out, do we stick to that second category of 2 to less than 10, or is that too broad? It's what we have now. Do we limit that to at least, sort of presumptively a county jail level, like 8 to 10 months or something like that, that allows for an adjustment for factors or for subsequent offending or things like that? How's that all work? If we can get sort of some basic consensus around some of those things, then we can build sort of the same protocol, use it to build for marijuana, as Senator Street talked about, that would be greatly reduced, and build it for cocaine, and build it for fentanyl and for meth and other drugs.
I think there's one last thing for sure. I don't know in everybody's counties what percentage. I'd be curious to know of the heroin also has fentanyl, because I know then it becomes fentanyl, but isn't that another tool? If it has heroin and fentanyl, one of the things for cooperation is we'll charge, or you can plead to this amount as heroin as opposed to fentanyl. It's just a thought.
Yeah, I'm not sure how that operates.
Maybe, I don't know if we can find out.
PSP can do with that?
Maybe, or DEA. Yeah. So we can check into that. Well, look, I know we've discussed this a lot, but it was really helpful. If you have any other thoughts or comments, send them our way. I'll work with the chair and vice chair just to sort of figure out what we're working on going forward. But I appreciate this. I know we have a lot of other things to talk about.
And when will we discuss whether we're going to do something in between now and the next meeting?
Yeah, I thought at the end of this policy meeting, we'd make sure that we talked about whether it's a separate day or that Wednesday before the next meeting. Okay, so if it's all right with everyone, what I'll do is move on to one other quick topic just to highlight it for you, and then turn it over to Matt for some other issues. So let me move.
Sneezing in your mask, you need a new one.
So one of the things we talked about at the briefly at the policy meeting was Murder 3 and how it's sort of all over the map, and we provide a lot of information for you about where Murder 3 fits into the current guidelines. And in the handout you have the two matrices, right? On the one side is the current matrix, and just recognize that Murder 3 is at OGS 14, so the range is 72 months to the statutory limit, so basically to 20 years. And then on the other side is are the proposed ranges, and if Murder 3 is at the top of the list, we put it at 35, which has a range of 102 to 114, or something like that, up near the top, along with what we talked about yesterday for IDSI and rape, where the victim's less than 13. So we provide a lot of data to you previously. This is, this distribution of sentences for Murder 3 is here, and you'll see at the far left-hand side, there were actually some probation cases, and at the far right side, you'll see that the biggest column is greater than 120 months. So remember, you can go up to 240 months, right, for a minimum term. So you see there's a sort of a mini spike at 120, but then greater than 120 is the aggregate of all the others. So you have a lot in there. So I'm going to buzz through a bunch of these slides that we had, but one too many, to get to this one, which is the frequencies for murder 3. Remember, 0 prior record score, no enhancements. This is like a pure murder 3 case, and there were 57 of them during this period of time that we were looking. Now, this was, I think, only 1 year of data, and so we can update this based on the work that we did. But if we just use this as an example and you look at where the numbers are, you see it at 120 months, so a 10 to 20 or 10 to 40, whatever it is, we had 11 cases. Then you see at 180 months, there's 8 cases, and then at 240 months, there's 14 cases. And, one of the things we've been trying to do is sort of look at what we've seen in just example cases from Villanova Workshop and other things like that. Like, what are the kind of things that contribute to this really wide range of sentences for murder 3? And it's sort of this default category in both directions, down from murder 1, up from voluntary manslaughter. But it's this whole mix of things that happen. And so that's partly why we have this huge range. But we're trying to narrow ranges and be more focused. So one of the things that we've been talking about is, maybe the proposed matrix needs yet some more categories. But one option would be, think about that top white category where you have murder 1 and 2 and adding murder 3 there. So think about 2 categories that you'd have the bottom 2, you'd insert at the bottom of the white area, murder 3. And I'm not sure what the range would be, but one of them could capture, 180 months, and another one could capture 120 months. And you already have one for the murder 2 default of 240 months. So at least it would give you sort of some categories to figure out what kind of range might be appropriate for murder 3 for that sort of step up, step down kind of thing. And it would just make it a little bit more susceptible to targeting if we could figure out what kind of factors would justify or be appropriate for a sentence of a recommendation of 240 months or 180 months or 120 months. So that's just a starting point, but the idea would be insert, you'll see it H1 through H6, insert H7 and 8, have those, particularly for murder 3, but thinking of 180 and 120. And then you get down to 35, whether that's a mitigated for murder 3, maybe that's the lowest category of murder 3, or maybe that's reserved for things like rape and IDSI, and murder 3, is sort of exclusively up in the white band. But just something to think about in terms of giving us a little bit more latitude in coming up with recommendations for murder 3. Because right now, 72 months to effectively, 240 months is, without any suggestions, recommendations, is not what we're trying to do with these new guidelines. So,
sort of the history of this.
Sure.
I was a homicide prosecutor, and you might remember, you're probably the only one that does besides me. I mean, for many years, murder 3 and max was 20 years.
That's right. Yep.
So it was 10 to 20.
Mm-hmm.
So, I would sit with the victim's family and talk about a possible plea agreement to a max third degree for 10 to 20. And I'd have a mom looking at me saying, look, my 18-year-old son was killed by that 21-year-old. You're telling me he's going to be out when he's 31? Yeah. And those cases went to trial and otherwise. When the special session came in and they made it 20 to 40, that really gave, that was a lot more palatable, I think, to a lot of victims' families to get a 20 to 40 sentence in those. And I'm talking about plea agreement cases here, and again, if it's a plea agreement, you can disregard the guidelines,
Right, yeah.
you know, if everybody's on board, but I'm just thinking, you know, that's one thing I'd like to keep in mind with that. Yeah, and the other thing is, you're right, it's broad. I had, you know, a lot of trials that I thought were first degree, the jury came back and said third degree, and I thought the guy should get maxed on that, you know, because, but, you know, the jury spoke and whatever, so I don't know how you define, because there's so many variables for third degree.
Yeah.
You know, sometimes it is that, you know, when it arguably is a first degree case, then, you know, the fact finder says it's third degree, and you live with that and go on, but then does that mean you're looking at the, you know, 72?
Right.
You know, and
Well, see, so here's the thing, and, you know, we can sort of think outside the box, but right now, because it's so broad and we really don't recommend anything except the floor, we don't have good information on why whatever's happening is happening. To the degree that you create three categories, even if you created murder 3 as low, medium, and high, but, you know, indistinguishable, but the court gets to determine it and provides reasons, at least you'd start to build some understanding of why 240, why 180, why 120, if those are the three sort of categories. So, so part of it is just trying to understand what's happening and then see, you know, if this sentence is given based on those factors, what's the outcome? You know, is that good or bad? Does it work or doesn't it work? I mean, that's sort of what our job is.
I just don't know how you do it.
Yeah, no, I know.
Categorize.
And one of the things, I've had some discussions with some judges that said just homicide, just to see if we could pull together a group just for a discussion of this issue, like murder 3, what are some options? Certainly, you know, a lot of cases come out of Philly, and so there's you know, there's just a docket for that, and that would be one example, but clearly, you know, Allegheny and other counties have,
I
you know,
just wanted to, given the variety of murder 3 cases and the very different circumstances that could exist, I would be reluctant to want to reduce the number of options that the judges have in sentencing. I just think that we have to be very careful because and I think the reason that there's a significant number of different categories is because there are a significant variety of circumstances. I mean, murder 3, you know, involves often provocation. What the provocation looks like can be very different. What the mitigating circumstances that take what would otherwise be murder 1 down to murder 3 can be very different. And I just think there needs to be some space for nuance in sentencing.
Yeah, and thank you, Senator. And I hear that what we as staff are trying to do is looking at what we have posted right now is the proposed matrix, and you know, we're going to have to recommend to the commission, like, where do you plug in murder 3? And if we plug in murder 3 in this proposed matrix and we do it at 35, then we have reduced the sentence recommendation from right now 72 to 240 down to 102 to 114. So that seems like we're restricting options there. And so that's why I'm thinking if we create 2 categories of H5, H7, and 8, and maybe it is a big bandwidth, you know, maybe it's 120 to 180 and 180 to 240 for those 2 categories. I'm not sure how you define them, but, you know, the other thing is you could have one big category of, you know, 120 to 240, but that's, you know, we're trying to see if we can narrow things, but at least with the present draft that we have here, the proposal, if we don't insert something for murder 3, then we're sort of stuck with 102 to 114.
I think you have to insert something.
Right. So then the question is, you know, is it one thing? Is it like we'll put in an H7 of 120 to 240, or is it helpful to have multiples where we at least try to split it up a little bit and try to get a better understanding of what's happening or what we should be recommending?
Well, if you put in just one category, aren't you in essence mimicking what we have right now?
Right, and
then we have no
that's my
granular-
concern.
yeah, we-
That's exactly my concern.
There's
And
no
that's why
guidance
I'm
for judges
saying,
and no granularity
right,
in terms of the data we're getting back.
so if you could do a murder three and have, two categories there, and whatever kind of split you'd have, that at least would offer something. And like I said, we can discuss with judges that sit homicide a lot, just trying to sort of think through murder three, and are there factors that could be articulated that would contribute? Like you said, Judge, when you're, if this seems like, if it was a bench trial, it would have been murder one, but the jury came back murder three, what are the factors or elements that contributed to you getting there? And is there any way to build that into guidelines? And clearly, we have probation cases, but we certainly have, lower cases where, it's a voluntary manslaughter that because the jury was forced to decide, went with murder three. So you have, in both sort of ends of the spectrum, you have that stuff. So I just want to build in discretion. So to the senator's point, I think it's a good point, but we don't have it in this scale right now, in this matrix.
To Senator Street's point, I think all of us, I think we all agree you need to do something.
Okay. Well, how about if staff, tries to have some conversations and at least considers building in something in the murder section for a murder three, and maybe a couple of categories or whatever. We'll try to have some conversations. We'd appreciate any thoughts you have, and then we'll bring it back at our next meeting just to sort of test run it.
Mark, this is Judge Tucker. I think the
Yes,
conversation with the homicide judges, especially in Philadelphia, would be time very well spent. It's been a while since I've looked at the numbers, but I would think that of the homicide convictions, the bulk of them are in the murder three category, be they pleas or trials. Just a firm thought that I have is based on the experience when I was sitting in homicide and when I was supervising judge of the criminal section. So it would be time well spent, and the information I think would be invaluable in terms of conversations with the judges regarding murder three.
Great, Judge. Thanks. And I'll follow up with you because of your experience in this area. We can maybe schedule some meetings. Appreciate it.
Sure.
I think we're going to finally turn over to Matt for a bunch of other related issues. So.
Okay, great. I think that the methodology that we've been looking at, or the approach of this descriptive versus prescriptive, not only applies to the OGS categories, but also as we're thinking about prior record scores. So since it's been a little bit, and consistent with what Judge Bernstein said yesterday of just needing a little reminder, I think it's worth revisiting what our proposal is for the prior record score, and then some conversations and looking at some data as it relates especially to restricting it to prior record score to twice the base. There was conversation last session about, is that the appropriate restraint, or should it be greater than that? And bringing some data to bear about current practice, I think, will help inform that discussion. So at the highest level, just as an overview, if you remember, we're moving from 8 categories currently to 4 of none, low, medium, and high. We currently have this point-based system where, if you remember, the accumulation of those points is based on a lot of permutations in different ways that you can get 3 points or 4 points based on your prior convictions and juvenile adjudication. And now we're moving to a system based on the statutory grade of the prior convictions, also considering the number of these priors, as well as if there is a single or multiple victims. We will also talk at the end of this short presentation about an issue that Judge Tucker brought up revisiting our thinking about juvenile adjudications and how those juvenile adjudications count into the calculation of prior record score by considering both decay and gap policies. The current proposal includes a lapsing provision for adult offenders, which is currently not in the current version of prior record score. And then I think where we'll spend most of our time is thinking that OGS is the primary driver of the sentencing recommendation, and that our recommendation is that the highest category is roughly 2 times or no more than 2 times the recommended duration of the lowest category. And again, we'll bring some data to take a look at that from a descriptive approach and see how that may correspond with our prescriptive categories. So as a quick review, again, we have 4 categories that we're proposing now. None is the easiest with no priors. Low is 2 ways you can end up in the low category. One is where the most serious prior is a misdemeanor 3 or misdemeanor 2, and that could allow for multiple incidents or multiple victims. Low would be our single incident and single victim misdemeanor 1. The idea of the single versus the multiple, you could look at the medium category for B, where that misdemeanor 1 would move over to medium if there are multiple incidents or multiple victims for misdemeanor 1 or for felony 3s. And then medium A is a single incident and single victim for felony 3, felony 2, or felony 1. And then our highest category for prior record score would be multiple incidents or multiple victims for felony 2s or felony 1s. And in our conceptualization, that's somewhat consistent with our RFEL or REVOC categories that we currently have. So this diagram is showing the distribution of individuals based on 2018 data who would fall into the proposed categories on the left and our current categories on the right. So a couple things to note that our current prior record score of 0, as you know, is not a true 0, so they could have a misdemeanor and still be in prior record score 0. So we're reducing the number in our none category, our lowest category. Now it's about 1/3. It was roughly 1/2 previously would fall into our lowest category. We're now roughly evenly distributing individuals into low and medium, somewhere about 30%. And at the high category, we now have 5% under the current, at least in RFEL and REVOC, and there are some individuals, excuse me, who are currently in PRS 5, who would be in our high category. It's slightly higher at 5% than roughly 3% under the current edition. So, well, it meets our goals, again, of simplification, which would allow for the automation component. I think that, we've had lots of discussion in our academic review panel, who met many times, talked about what the role and purpose of prior record score is. And there's, of course, the retribution factor and thinking about culpability, but there's also the idea that it's somehow a proxy for risk. So on the left is the new categories, and we could see, at least using data from 2004, 2005, and 2006, which was our risk assessment construction database where we have recidivism information, that there is a step up between our categories of the current proposed PRS. And in the current version, the studies that CMU and others did when we were looking at prior record score in the past, we see that there's very little difference once you get to PRS 3 from the point-based system. And some of that, again, is, I think, because of the amalgamation and the way that those higher levels are calculated, that as I mentioned, how you get 4 points or how you get 3 points can vary in lots of different ways. So if we think about that now, the new construction at least is consistent with this other rationale for prior record score, which would be that it does capture increased risk associated with people, or risk of reoffending or reconviction with people with higher prior record score categories, whereas the older one, certainly at the low end, but then really distilled at the highest end. So something we've talked about quite a bit is what that extra punishment is, or what the recommendations are as we move across our prior record score. So this diagram looks at the comparison of prior record score 0 to prior record score 5. In the past, we've compared prior record score 0 to RFL, but because of the lower numbers of individuals, we chose just to focus here on prior record score 5. So we take the lower limit of the standard range and we make that comparison. We see here, for example, that the lower limit of the standard range for prior record score 0 is 3 months. At prior record score 5, it's 21 months, so that ratio is 7. If we looked at RFL, that would go up to 9, as it would be 27 months is the lower limit of the standard range at OGS 6. And then we move up and we see that that ratio diminishes a little bit, but it's certainly for OGS 6, 7, and 8, 9, in excess of our 2 times that we're talking about from low to high. And that's, I mentioned, magnified even more when we use RFL. But we chose to use PRS 5 because we wanted to actually look at the median sentences that were imposed, looking at data from, I believe this is 17, 18, and 19. And we see that if we look at the median sentences for these, the ratio now for OGS 6 is 3.5. So another way to think about this also is if you look at the medians for PRS equals 5, for OGS 11, 10, and 9, that the median sentence that was imposed is actually lower than the lower limit of the standard range for those OGS categories. And we see on the far right, those ratios, almost every one, 8 of the 9 are lower than the ratio of the lower limits from the guidelines, with 1 being tied at OGS 13. And for the most part, they're moving in the direction of a ratio closer to 2 than it was looking at when we looked at what the guidelines were. So when we were considering and thinking about this at our last meetings, we didn't provide necessarily any data to suggest what it looks like in practice. So descriptively, at least, it looks like that judges are giving somewhat of a discount to the prior record score values, or another way of thinking at it is potentially the current prior record score values are too high when judges are working in practice and thinking about how they should be implemented. So one last set of data just to think about. We looked at, for all OGSs here, this is the conformity rate by prior record score. So the blue line, the first bar represents sentences that are mitigated or downward departures. The oranges are the standard range percentages. And then the gray, the last bars are aggravated or upward departures. So a couple things to note here, and I think it's consistent with that idea of what we just looked at of those median sentences and the ratios, especially looking at OGS 5, is that as PRS increases, as we go from 0 to 5 into RFL, the percentage of cases in the standard range declines. And the direction they're going is that there are additional sentences that are in the mitigated or downward departure ranges. So I think this is just consistent with, again, in practice, as the prior record score is increasing descriptively, when we're looking at what judges are doing with the guidelines, that they may be viewing that ratio that can go up to 9 or 10 amount maybe as too much. So I think that the medians, at least, were somewhat consistent with our recommendation of no more than doubling the values. So if we were to look at our proposed matrix that you have as a handout, and we make those comparisons again of the lower limit of the standard range, So we're looking at, for example, at OGS 25, the lower limit of the standard range for our new prior record score category of 0 is 42 months. And then at our high level, it's 60 months, that ratio is 1.4. And then it increases slightly up to 1.8 as the ratio at 21. And you will note that there are some on our proposed matrix that do exceed 2, but just by a small amount, partly because of the short duration of the sentences 1 to 3. The way it works as you go across, it just had to fill that space and be slightly greater. So before I move on and start thinking about or talking about some of the lapsing provisions for juveniles and adults, any additional thoughts on this idea? I know there was some concern or discussion around, was capping that none too high at 2, maybe too low, but again, I think the data here at least speaks that is consistent with current practice, but this is where descriptive and prescriptive intersect in this conversation.
Matt, what's the B in parentheses, the number? In like 72 statutory limit, what, like, how does that play in? What's?
Oh, that's the REVOC versus the RFL.
Oh, so we're still going to have RFL and REVOC?
The two thing, there is just in that combined category. And we have to probably refine that a little bit, but the idea was we knew those were exceptional kind of sentences, so we wanted to sort of reserve those off to the side. And we see them as the high category, but there's two different flavors there. And as you know, the REVOC only applies to certain cases, so we wanted to reserve that.
Okay, any other additional thoughts? And I think that this morning's discussion also informs this of the OGS, using that for second, subsequent, also moving up on the OGS category, not just moving across for certain types of offenses, is another mechanism that we can take into consideration when thinking about what this ratio is, at least in terms of the impact of increased sentences for prior record score or for repeat offenders. Okay, so moving on just to finish the prior record score piece, working with the academic review panel and then reviewing what is done in other jurisdictions and states and thinking through the role, as Judge Tucker said, of juvenile adjudications yesterday and how they're distinct from adult convictions, we're proposing here a more liberal lapsing policy for juvenile adjudications. Consistent with current practice, misdemeanor 3 and misdemeanor 2 juvenile adjudications are not counted in the prior record score calculations. We're proposing here decay policies, which simply mean that at a certain age, they're no longer counted. So for misdemeanor 1 and a felony 3, those juvenile adjudications would no longer count towards the prior record score calculation at age 21. Currently, all of our provision is a gap policy, which is crime-free between 18 and 28 is our current provision. So again, this is a little more liberal in that approach of not needing crime-free for that or for felony 2s or felony 1s, which would lapse at age 25. And then for crimes of violence, it's requiring crime-free between 18 to 28 years old. So a gap policy, but specifically for those, what we think of previously as our 4-point offenses on the prior record score. So any additional thinking on the juvenile lapsing provisions, because again, it is I think, in response to what we heard from the academic review panel and from others of the differences of juvenile adjudications, but recognizing that juvenile adjudications are also a predictor in terms of risk levels of future criminality and convictions.
Yeah, and if I could just add one thing, under our current guidelines, we do have a policy or provision that talks sort of differently about what are things structural about the guidelines, like how do we determine and calculate the prior record score, what counts and what doesn't. And then separate from that, the court exercising discretion. And so there could be these kind of situations where we have a policy that says, based on the age, based on whatever else, these things no longer are included in the calculation of the prior record score. But we could also have that the court may exercise discretion in considering, high volume, juvenile offending, whatever, in terms of an aggravating circumstance. So we have language in our guidelines right now about sort of on both sides of the equation. Really stale records, although you build them into the prior record score, the court can discount that by mitigating. And if the prior record score doesn't reflect the seriousness of the criminal history or whatever, the court may aggravate. So I'm just saying that even with these lapsing policies, where you remove it from the calculation, if you had concerns about underestimating criminal behavior because the person continued to offend or something like that, that there is an opportunity for the use of discretion by the court. So that could be built into the guidelines. And I think that gets to especially that crimes of violence part. Because remember, if you look at the list of crimes of violence, it includes burglary of house, person present. So you could have a person adjudicated delinquent of that type of burglary, 17, and that's a crime of violence. So that would continue, and there's a gap policy in place, and I forget if gap means crime-free. And if it does, then if there's any kind of offending between 18 and 28, that burglary would remain with the person forever. So that's one of those kind of issues about whether it should be gap or it should be decay. But then it also gets to, should that be an area where the court can exercise discretion, saying, yes, even though it counts, I'm going to recognize that as long ago, and I'm going to mitigate, or you change it to decay, and when it's out of the mix, if there was continuing offending, the court can exercise discretion to aggravate. So I think we just have to keep those two aspects sort of in tandem in consideration, because it's about structural things versus the exercise of discretion.
Okay. We also talked about at the academic review panel and in lots of other discussions about stale criminal records for adults as well. And so the proposal here is saying that for M3s, M2s, M1s, and F3s, that a crime-free period of 10 years, they would no longer be counted in the prior record score. And for felony 2s and felony 1s, crime-free for a 15-year period, would discount those. Now, one aspect that we still haven't, maybe we've talked about a little bit, but need a little direction on is for those crimes of violence for adults. Should there also be a gap or decay period for that special category of prior convictions, prior adult convictions, that we would add any sort of lapsing policy, or do those just always remain in the calculation of the prior record score? So I don't know if there's any thoughts on the juvenile piece or on this adult piece before we move past prior record score. And again, we would welcome any insights into additional analyses that you would like related to the prior record score categories. And
Matt, if I could just throw in this category about adult conviction lapsing, one of the other discussions by the strategic planning work group, and this might be particularly for crimes of violence or something like that, was is there a period of time, sort of a gap period, for which the offenses don't go away, but there's a reduction in the value of them? So we're more categorical now, so that's a harder fit in terms of how do you implement that. But you could be moving from, high to medium prior record score, not always stay in the sort of the high, which is the Reebok RFL category. So there could be a mechanism where you allow that shifting after some period of time, but you never lose that. So that was, that's something that could be built in for certain types of offenses if you didn't want a full out gap for certain for things like crimes of violence.
Now, how are you defining crime-free? Does that include summary offenses, disorderly conduct, public drunkenness?
I mean, currently, we don't necessarily have a final definition, but it would be consistent with previous, I think, that would not include the first of those.
Yeah, so misdemeanors and felonies, sort of court of record things, but not summaries.
How are ungraded felonies treated?
Like misdemeanors and like felonies. So I think, I see what you're saying. I think we put them in the felony 3 category.
I think that's correct.
Yeah. And that's another thing that, we can look at. I know we did some analysis on that, trying to figure out where to plug it in, because in some of the stuff we looked at, it was considered in that sort of lower tier of felonies, and in others it was, because of the classification of the statutory max, it's between F2 and F1. And then you have that whole doubling thing because of the way the statute is written. So, we're open to that. But that again gets to that whole interplay between, what are the adjustments we do on the OGS scale for like those second or subsequent where we take into account that those kind of ungraded felonies are higher.
And how does that work if it's 20 years later, so it lapsed or gapped for guideline purposes, but then does it aggregate for OGS purposes under your proposal?
Yeah, I mean, again, you're in the pay grade that you get to make that decision, but I think, I think we have to be consistent, and I think if we're saying that repeat offending, applies, we should have it consistent across the board. So if we're removing it from the prior record score after 15 years, we should look at that as a policy on the OGS side. But you can decide, nope, 2 different things. So,
I mean, I think generally, I think this proposal is pretty good. I think crimes of violence, though, I'd stay in. I just think, it is what it is. And a judge can always discount and say, it was a simple assault 20 years ago, which we do now.
Right. Yeah, that's the discretion part of it.
Yeah.
So.
Okay, great.